in CIL.
Next week, any date also.
No. Bail will come in CIL.
355.
Whatever, but bail will come in CIL. I will not deviate from that. All the matter will come next week. Don't worry. All the matters will come. I finished all the matters. He will not tell. Automatically it will come.
One matter, admission 38 and 2 orders matter. Matter that may be taken up next week sometime or a week after.
Which one?
11, item number 38 for admission. This admission attacked with another 1 or 2.
No, this is weekly.
Supplementary.
We want an adjournment.
And then next week, or after vacation. And 2 orders matter there, no. I should not make mention, but I am little badly placed to do. Order number 1 and 11. 11 I am the informant. I have not received a copy of the petition. But I was asking for
it's a problem also, my lord. In the item number 11, there is the schedule it is another file. CRLM 2068, my lord. Which file is just right now I am receiving from.
And then I will put it next week. Next week, 11, along with that CD in the other matter. What is that?
Yes.
In which matter CD is there, you just tell that.
Yes, ma'am.
Yes.
that is it.
Yes. Okay.
And another, the item number, the.
Today you want to go home, it seems. All the things you will do and go home.
Otherwise, I would have gone from the home manner. But
Yes.
it's a pleasure to come to the court at this age.
Yes, always. Yes.
This order number 32.
32 item number.
This is notice matter.
Yes.
But whatever needs to be addressed, let it come next week sometime.
Note it down and let it. Let the others will come.
32.
Admission notice should be written on certain. No such address section.
Then you
I think State Council is a police officer. The notice I had given the copy.
I'll pass appropriate. Put the tick, I'll pass appropriate.
Okay.
Item, my lord. Item 13 can be taken up to vacation. 13. That was what happened, my lord, that petition law is on as a interim there. Sorry, there was certificate not received till now.
That's not out of list matters. Two criminal divisions, your lordships remembers, I have filed against my refusal my application for discharge. In the status, it was showing that it is to be listed on 25th, but 25th is not listed. Trial court has fixed the case to 3rd October. And no interim order is there on the understanding that it can be disposed of in one go. My friend is appealing.
I don't remember what he did.
That 2 matters will that the main accused died.
The complainant died and the handwriting expert reports that there is sufficient materials are not there to.
Any not my lord, let it come and explore the feasibility in pursuing the court, not the matter anywhere and another adjournment given.
No, 25th.
The
status.
What do you want then?
But on 30th, let it come on 30th so that on 3rd the trial court has fixed the date.
Put it 30.
That's item 2 was kind of after vacation. Item 2.
No, can't you wait? Item 2.
Lots of
Young man, you should wait. You wait. Item 2, I can't wait.
So this is a criminal misapplication.
And get ready, really. I'll ask you.
But let's say it was in the list last week, that before week.
Yes.
But that since code was didn't function, the matter was the list.
I didn't follow you. What you
The matter was in the list.
Yes.
But there are
In this code.
in this code.
Yes.
But that day, since the code didn't
It should not be taken up.
Yeah, the code didn't function that. The code didn't function that day.
What is this matter is about?
No, there is a CMMC. Here, I have for the bank. Here, our gold ornaments have been seized and I paid for interim release.
Bank, why bank is so desperate?
No, bank, it is the bank, where the number institution.
That right, but bank.
Lordship was of the rule that to die for release on certain condition.
Give it, we'll see. We'll see how can we adjust. I'll try and get it. Yes.
Oh, blessed.
Yes, sir.
Item 53 may kindly be conducted.
Today I'll take it up. There are very less number of matters. It may reach before lunch. Be there, I'll take it up.
Oh, blessed.
If the other side is there, you can call.
We have already discussed.
Yes.
Last time
I think before lunch it may reach. Many people are asking urgent.
Huh?
opioid.
What's the
The
item?
opioid counsel should be there, otherwise,
What's the item?
yes.
What's
item-
the item 39 and another item 43? No, similar and accommodation.
39, 43. What are those matters?
Patient report. Yeah.
39, 42, रख दियो.
Three.
हाँ, वही सब, no problem. Yes. Yes. Actually, you did.
Yes, not, he's not available.
This matter, this matter, man. What is the sentence?
This challenge the order passed in section 3 of criminal law amendments ordinance 1944
Yes,
attaching the civil property.
the attachment.
Attachment.
You have to give the copy.
A copy will be given and Mr. Sanjay Das' name may be recorded
Something
for the opposite one.
and supply a copy.
It has been made on behalf of Sanjay Das.
Yes, supply a copy. We'll see. I'll take it up. Huh?
मैंने पोर्टली के से जो
Let me for the petitioner, appellant.
मैंने जो अपनी कमेंट supplying copy to the
But they have to read it, otherwise, advance copy you have not supplied.
and supplied, but inadvertently that is not so.
They found up stage. And so let the counsel for the appellants undertake to supply the advance copy of the appellant to Mr. Sanjay Das, advocate for the vigilance. During the course of the day, leave the matter.
Item 2.
Yes.
Item 2.
What is this matter?
Matter is, let's say, the petition challenge the order passed by the Lawrence Special Judge Vigilance in tier number 52 of 21.
What is the order?
page 20.
Page 21.
What is the order? Have you read it? I'll not adjourn. You read it and then only I'll read it. You sit down, when you will complete, then tell me. Without reading, don't come to the court.
At the same time, let me also go to the page 30. Page 30, sir.
Two witness has been examined.
What are you seeking in this petition? Every time you are coming, only you become an adjournment master without reading file. You read the file and tell me I'll adjourn it. But without reading, don't tell me. You must tell me at least the facts. Then I'll adjourn. At least you read the file. This is the last warning, okay? Next time when you come, to read the entire file, I can ask any pages and all. If you can't answer, then I will not adjourn. Adjourn. Yes, adjourn.
Item 3.
May legal similar
Yes.
420.
Maintain your page 30 was indicated, but he has gone through properly. The charge has been framed against other accused person. In the meantime, and two witnesses are been examined. This is at page 30 of the impugned orders. Let him get that instruction where of calling the charge.
Will you follow? Legal persons are concerned, charge has been framed and evidence is up. Either he stay here, no stay. And then charges might have been framed against him also.
This is Tanga's senior now.
Verified. Huh? Yes.
Item 3.
May legal custody 8/4/2024. 420.
8/4.
2024. Yes, 420, not named the affair. And my lord, he had taken money in order to provide a gold coach. And individual Chitrasana Kosala, he enlarged and bail by the order of the minor. And so far as the petitioner is concerned, we know.
He is guilty.
See the main accused. He had taken money. My name does not influence the affair.
What are the conditions? Not sure. You were sold that gold punch
That my lord Chitrasana.
and taking 4,35,000.
Yes, my lord, he had taken. Moral, absolutely teaching.
What are the allegations against you, Ladakhi?
I only assist him. That much allegation. Though my name does not find place in the affair, subsequently the prosecuting agency on his confessional statement, my lord, I being arraigned as an accused on the allegation that I assisted him.
Leaving to see the brass mental coins for the complaint under execution seizure list, apprehended the accused Chittranjan Khosla, interrogated the said accused, disclosed that he along with the petitioner have cheated the. So, what the custody since 8/4/2025. Not the petition না petition আছে and petitioner is assisted তারপরে এটা তো লিখলে হবে এই what the petitioner denied to petitioner দ্বারা লিখো চিত্রসেন ঘোষাল ঠিক আছে the present petitioner is alleged to have assisted the co-accused Chitrasen Khosla in the entire privacy. Hence, the next order, Chitrasen Khosla, co-accused, filed a BLAP number 4993 of 2024. This court, by the order dated 12/9/2024, enlarged him on bail. The petitioner is seeking parity with the said co-accused and states that the role attributed to the petitioner is much more lesser than the co-accused Khosla. Regarding head to the fact that regarding head to the period of custody from 8/4/2024 and the nature of accusation against him, so and the co-accused granted bail, the petitioner is admitted to bail. Yes.
Please, my lord. My lord, the last occasion your lordship directed the petitioner on interim bail for 20 days on the ground of his father's demise.
Yes.
He has surrendered in time. Surrender date is 23/9/24.
Your file certificate.
My lord,
File certificate.
already.
Yes. I will session that report regarding surrender of the accused at Clap K.
My lord,
By the order dated 3/9/2024, this court has enlarged the petitioner on interim bail for 20 days on the ground that his father had expired. Then consequently, the petitioner submits that he has already surrendered before the jail authority and filed the surrender certificate. Yes, madam. My lord. Surrender certificate. Needs the matter for hearing. After vacation, okay.
I will file some deposition, my lord.
Whatever you want to file it. We'll write to that.
I can file.
My lord, on behalf of the learned in pass over this matter.
Pass over, okay.
Item 6.
My lord, the petitioner is in jail custody since 13/11/2023. It is alleged that the petitioner along with another person ready to transfer 81 kg 300 gram contraband ganja.
Prior to that, my lord, this matter adjourned to 5/11/2024, my lord.
My lord, just previously called তারপরে মেডিকেল কো ଯିବି
How this has come then?
ଗୋଟେ ରହି ମାନେ my lord ସେ ରହିଗଲାଣି ତେଣୁ ଗୋଟେ ତା ସ୍ତ୍ରୀର ଦେହ ଖରାପ
Last February 11/2024. How has it come?
ତା ଦେହଟା ଖରାପ ଅଛି ତେଣୁ ସେଠୁ ମୁଁ ଆଇଟି ଫାଇଲ କରିଛି ଅନ୍ ହର ମେଡିକାଲ ଅନ୍ ଦି ମେଡିକାଲ ଗ୍ରାଉଣ୍ଡ ଫର
1 minute. 1 minute, sir. 1 minute. If there was an order on 3/9/2024 that as per by the counsel of the petitioner leaves the matter on 5/6/2024, how it has leased? This matter adjourned. Which order is there in front of me?
I will have.
Why did you say? Ask for the explanation, who is the person responsible? And people are struggling to get the matter listed, those matters are not listed. And matter is adjourned, these matters are listed.
And I file, they have not given.
IA
The main petition are the
IA matter.
notice I file,
But in fact, my lord, there is no such a.
Series by, yeah, that's the point.
Will be verified. Satanna.
When was the last order? What is this happening? I mean, registry people are doing according to their own ways, it seems.
But it's. Okay. Only file after that.
He had mentioned before this court.
Yes, sir.
For this interim.
18 September was filed interim for interim.
When I had asked them to release the matter. Just verify and tell me. Yes, interim order. On what ground?
Wife's illness, but they have not been supplied any medical report not there.
But seriously, we will not make anything unless you file some.
Documents, my lord, he had not given only
Nothing. That may problem in heart. What is this?
The medical officer directed her wife to examine.
You should have given it to the state council. You have given the application only without document. How will you verify?
My lord, document is there.
The main matter is listed, directed to be listed on 5th of November. Meanwhile, the petitioner had filed an application for interim bail on the ground that the wife of the petitioner is not keeping well. He has filed certain medical document in support of the said claim. However, the copy of the medical documents has not been supplied to the state council.
Only scan.
The petitioner is directed to supply the copy of the medical document form part of the applications within 2 days. The state council shall seek instruction after verification of the same. Release the matter immediately after.
If supplied.
If supplied, obviously, if supplied. Yes.
May pardon. Item 5 also was passed over. I pray for next week. The petitioner is 1.5 in custody. I'll bring some deposition copy and supply to lordship and
Next week or then.
next week in the meantime.
Surrender certificate also you have not filed.
Yes, I have submitted.
Surrender.
In the meantime, I will file.
But have you surrendered or not?
Yes, in time. In time. Because I himself has stated that on the date of property I was not there.
Okay, no problem.
Next week.
Yes. Yes.
Item 7.
May I please, lords? Yes, petitioner is the husband, my lord. He is in custody since January 2024.
Late date.
Exact date January. Okay. All the family member of the deceased deposed in the meantime. Flag C, your lordship kindly see. 11 in number.
What are the offences?
Offence, my lord, 498, 302, 304B. 6. Yes, my lord. All are turned hostile, my lord. Yes.
But what happened in this case? The
Flag C I have given.
working persons are arrested. This petitioner absconded for about 12 years. And poor persons convicted. This case, my lord, 302.
Is convicted.
No, 7 years, 302 not charge has been framed, my lord. Thereafter, they have been convicted for 7 years.
306.
6.
Okay.
And thereafter, they have, in appeal, they have been granted bail.
No, but insofar as your case is concerned, split.
Yes, split up, and they are torn hostile, all the witnesses.
Then what to do?
That is true, my lord.
Then we will be acquitted. If we will be acquitted, why should you kill him?
The witnesses not supported the case, my lord. So far, the witnesses were examined. 12 witnesses were examined so far.
Have you gone through all the?
Most of the witnesses were the family members of deceased. They have declared hostile.
Then what to do? We will be acquitted. Unnecessary, we saw the state, once he will be acquitted, we have given you. But give me the date, sir.
Exactly. January 24, your lordship. Dictate the order.
I am passing it over, do it.
Yes,
I am passing it over, okay?
after lunch, man.
You just check it up, in between, if any evidence is there, then.
They think we will decide. Total
12. 19 ଜଣରୁ 12 ହେଇଛନ୍ତି ଖାଲି official witness not been examined.
Just show me, so that after, yes.
Not supported.
After lunch, my lord.
Yeah. Yes.
Okay.
Exact date you must tell, huh?
The petitioner from my lord is in custody since 11/12/2023.
11/12.
My lord.
23.
23.
Yes.
For being charge sheeted for the offences under section 294, 326, 326A, 307 and 506 of IPC, my lord.
Yes.
Admittedly, there was a prior civil dispute between both the parties, but on the alleged date, on a spur of movement,
Santosh Kumar Marana.
my lord,
Yes.
the alleged occurrence took place. It has been alleged that while the
That file,
charge sheet has already been
well,
filed.
that's it file, but it exceeded that my lord.
14/3,
And the 2 persons are injured, my lord.
my lord.
14/3.
2024, my lord.
Yes. 3% injured.
2 persons, my lord.
One,
Two members. My lord, one is Adhikari Tarai,
he was sustained 50%.
Grievous and Rajendra Tarai.
He was sustained 4% of this.
But Grievous will mention.
Then the which part of the body? Face.
Yes, my lord.
Issued that.
Yes, my lord. Chest, scalp,
Abdomen, neck and back.
face, back, neck, abdomen, and Mr. Rajendra Tarai, arm, forearm, shoulder, and the grievous.
Yes.
Both are
Issued attack.
What is only privilege?
Petitioner is agreed by the order dated 21/2/2024, whereby the rejected.
A small
Subsequent thereto, on 14/3/2024, charge sheet has been filed. In view of the changing circumstances, petitioner is given liberty to renew the bail plea before the trial court. If such bail plea is filed, the same shall be considered on the basis of the material which form part of the charge sheet.
Yes.
With this observation, the petition is disposed of. Yes.
Your Lordships, item number 9. I'm on VC, Your Lordships. Item 9, Your Lordships, the petitioner was released on interim bail. But I'm sorry to say that he has not surrendered as yet. So I will, my lords may cancel the bail and take steps for it.
Yes. Given to
On 20th/6/2024 for the death on the ground that his father had expired.
Okay. On 2024, the coding bench for this court had enlarged the petitioner on interim bail for a period of
2 months.
2 months.
2 months, Your Lordships.
2 months. However, Mr. 2 months. However, the
Your
petitioner has
Lordships, 2 weeks. 2 weeks, Your Lordships. 2
Sorry,
weeks.
2 weeks. However, the
weeks.
petitioner has not surrendered. Ms. Pratyasar Naidu, legal counsel for the petitioner, submit that she has no instruction in this regard. Regard being had to the aforementioned, the regular bail plea moved by the petitioner is dismissed, and the trial court is directed to issue process to ensure the presence of the petitioner for facing the trial. With this observation,
Yes, sir.
petition. Yes. Thank you. Yes. Yes.
Yes, my lord.
What is this matter, sir?
302 and
302. Location to other. Yes.
Yes, my lord.
Yes, sir. Item 12. Somebody is there?
My lordship, kindly request another that my senior is illness.
What do you want?
Adjournment.
Seeking adjournment because
I know.
set of his senior.
I know, let him speak. Yes, what do you want, sir? You tell me.
302.
Tell properly.
Hospital. My senior is hospital illness.
Sorry?
My senior deho kharab achi.
Let counsel to take an adjournment on the ground of illness of his leader, leaves the matter. Yes. You get encouraged to speak at least. Otherwise, that had that innovation not to speak. Yes. Yes. Somebody has mentioned it.
No, I will submit that this
That's what somebody is asked for adjournment. Let it be adjourned. You are for petition, sure.
30 months.
Yes.
Item 14.
Let us look at to after. Okay.
Yes, 14.
Item 14.
May I please, Your Lordship? I'm appearing to virtual mode, Your Lordship.
Yes.
Your Lordship, in the present case, the petitioner was released on interim bail for 4 weeks. However, after being released on 25/7/2024, she was further arrested on 26/7/2024 in another case, Your Lordship.
So that's a surrender certificate did not file.
But you filed a surrender certificate.
Your Lordship, she did not avail the benefit of interim bail, Your Lordship.
So he is not a full, immediately he was arrested. Okay. What is this matter? Then you want to argue or withdraw? What do you want?
Lordship, adjournment I want. Short
Forget
adjournment.
about the interim bail, which you got, you could not avail. Tell me whether you have a case on merits for regular bail. What are the offences? The offences are not serious. 420.
Yes, my lord. What you use course of one crore something cash is in the account of this petition, my lord.
Okay.
And I have also taken the detailed instruction from the constable. Let us.
On request. Yes.
15.
15 मतलब I highly I granted bail. My mistake मतलब I written the year 2023 instead of 2023 I written 2024. PS and case number. Yes. I written 24 my lord. That is correct number is 2023 my lord. You have no application for correction. Yes my lord. I file a IA my lord. 1256 of 2024. The PS case is 317 of 24. My lord. 23 no, sir. 24. Where is the FIR you filed? Annexed the FIR, my lord. In my bail application. Annexure 1. Okay, 23. The correction you want, huh? My pardon. This is yes. Yes and SA, my lord. Session. I have granted in bail, my lord. By order dated 4/9/2024. The petitioner has already been enlarged and bailed, but he could not avail the benefit of the order because of the wrong mentioning of the FIR number. FIR number. Therefore, he moved an application. FIR number also, my lord. FIR and court number SA number जोड़ा अच्छी से तो year वाला भूल गए 24 है ये 23 for the FIR and the case number. Therefore, he moved this application for correction. Correction कर दो 2000 24 अच्छी ना 23 कर दो है ना FIR number रे 23 ठीक है okay allowed.
Petitioner before lordship and she is in custody since 30/3/2024 my lord. 30/3 my lord 2024.
Okay.
And my lord allegation against her my lord 314 IPC my lord. The fact of the case is my lord. Initially UD case was arrested. That is UD case number 6 of 2024. During course of investigation of the UD case, it came to the light that the deceased my lord was a minor and she had kept physical relationship with an Abhilas. For which she became pregnant my lord. And the present police in the course of investigation, SIO police you procured the affidavit or what is it?
Objection for bail, but it is offense against the state.
Lordship, that affidavit may not be accepted. It is a serious offense. Only some medicines has been seized.
Recovery is the problem. Recovery is a medical term is picked. Why do you want? Why do you want? Why have you kept it?
मैं आशा भी रखी करूँ मैंने हाँ yes
My lord, syrup, tablet, injection, pregnancy test, key.
You like a doctor?
And also, This is from, it is from Motu. That
Your Lordship, for a moment, only some medicines were given by the present petitioners. Charge sheet has been filed, yes, my lord. Only 1049 was against me, my lord.
charge sheet is not with me, but
Yes, yes, your Lordship, for a moment.
only for 314 is there.
The problem is if we wait for the informant to examine, material witness are giving like this.
My lord, in which manner they have obtained that affidavit. Last occasion, your lordship see that in the death case, the mother has come and she was crying inside the court.
When the charge sheet was filed,
My lord, I have given the charge, so certificate of
the Lord's it here.
against the, my lord, one object 376(3) and Poxo Act is there. The main act is, my lord, against the present petition 349 is.
Right. By the order dated 8/4/2024, the bail plea of the petitioner has been rejected by the additional sessions judge cum special judge Malkangiri in GR special case number 20 of 2024. Subsequent thereto, on 25/6/2024, the charge sheet has been filed against the petitioner for alleged offence under section 314 oblique 376 bracket 3 of read with section 6 of Poxo Act. Since the bail plea of the petitioner was rejected at the time of investigation and subsequent thereto charge sheet has been filed, I am not inclined to enlarge the petitioner on bail at this stage. However, petitioner can renew the bail plea before the trial court. If such bail plea is moved, the same shall be considered on the basis of the material a form part of the charge sheet. With this liberty, the petition is disposed of. Yes, next.
My lord.
Yes, sir.
Lord, here an adjournment was taken on the last occasion by the informant's counsel, saying that the matter was posted for examination of the evidence of the victim.
My lord.
Yes.
In this case, my lord, I
The victim has not been examined. 3 witnesses have been examined, none of whom have whispered anything against me. And here, my lord, if your lordship will look at,
But last order was
yes,
direction to transmit the evidence of victim.
my lord,
Direct to transmit the evidence of the victim after recording.
yes.
It has not.
Yes, yeah, my lord, my exam. What happened, my lord? In the court below, my lord, the matter was posted to 25/9/2024, the examination of the victim. 6 witnesses have come to the court, my lord. Due to some documents have been misplaced, the prosecution has took time, my lord. For which the documents will not be examined, my lord.
Then now the next.
Monday, my lord. Posted to Monday.
Monday without for the informant and the state jointly submits that this matter is fixed before trial court for recording of evidence of the victim on Monday. Is that what is the date?
Monday, 30th.
30th, huh?
It is actually 15th.
And it is expected that the trial court without adjourning the matter for on any pretext record the statement of the victim and transmit the same in persons to as per the direction of this court dated 12/9/2024. Least on 3rd, 4th. Let it be 5th is working day. That will be better. So that is working.
Don't mind.
No, 5th is working day. Why 7th? 5th everybody is coming. You also come.
My lord, and for the item number, my lord.
5th I have kept it, 30th is the date fixed for recording of the victim evidence. Let it be recorded and 4th. Yes.
My lord, I am for the item 8714 of 2024 for the accused Dipu alias Deepak Kumar Naik.
Yes.
My lord, the custody since my lord 18 February 2024.
18 February 24. Okay.
My lord, the accused arrayed as accused in the basis of the confessional statement of one accused Sheikh Sanatullah and Golab and Rayamunda were recorded 27 Evidence Act, and the statements similar the present petitioner arrayed and accused while they are in police custody.
Yes.
But nothing incriminating material has been seized from the possession of the present petitioner. Charge sheet has been framed, no TI period, and only the present petitioner personal mobile has been seized, and that call register is not indicated that the involvement of the crime of the present petitioner. So in view of that, my lord, in the meantime, in his custody, my lord, there is no allegation against the present petitioner. So my lordship may kindly consider any stringent condition to release, enlarge and bail, my lord.
Yes.
It is 395, 25, 27 Arms Act. Yes, some item, my lord, only mobile phone was seized from the present petitioner.
No, I
There is
think.
no, my lord, there is no such allegation. Only allegation on the basis of a confessional statement, but nothing was seized. But
Okay.
last one, my lord, petition number 1 and 3, from them pistol and ammunition magazine, it was seized.
SK Sanatullah, Rayamunda and Gulavalli. And all these people recovery is made.
From petition number 1 and 3.
1 and 3.
Sanatullah and Gulabani.
What is recovered from them?
My lord, that is pistol, ammunition, magazine, everything was seized.
And what about 2? Petition number
Only 2, it against petition only mobile and that vehicle which was used for offense, that was seized.
Please. Whose vehicle was that?
That is the present petition of 2 vehicle, my lord.
His vehicle was used.
My
vehicle. Yes. And insofar as the subaltern is concerned,
no, some item only mobile phone was seized.
personal mode and TI period has not been.
No TI period is concerned.
Only confessional statement, 27.
My lord.
Who was arrested first?
Man, say your petition number 1,
Confessional statement.
petition number 1 arrested, my lord, first.
Section Aula.
First, man, Sheikh Sanullah.
Sanatullah.
My lord.
Who was arrested when?
22 to 2024.
22 to 2024. 24.
My lord.
No. Then he says his client was he is in custody since 8 to 2024.
18 to.
18 to.
My lord.
But still you were arrested prior. Who is arrested first?
18, my lord.
Be sure about what you are saying.
Yes, my lord. Arrest memo is with me, certified copy.
Who is arrested? Whose confessional statement was recorded first?
My lord, here, the statement of the Arun Kumar Sahu, your lordship have a glance.
I will not have glance. You tell me.
Yes, my lord, Deepak Kumar arrest memo shows that at 19 to 24, arrest memo was prepared. 19 to.
And you prepared. None of you are prepared about all
No, no, first case, my lord, that is 20 to 24.
My lord,
22, 23,
24, my lord.
whose statement, confessional statement is recorded first? That I want to know.
My lord, let it pass over.
Yes, pass it over.
90.
Yes, my dear lordship. Lord, the petitioner is in custody since 31st 8, 2023, Lord. More than a year in custody, Lord.
Yes.
Specific allegation regarding the assault, Lord, there is against the present petitioner is not there. But the out of sudden grave and provocation, this incident has been occurred. That is admitted in all the eyewitnesses have also stated.
There are eyewitnesses.
Yes,
Eyewitness is there.
But
Wife,
evidence of 1 or 2.
my lord, indeed. That wife, my lord, wife, who is the informant also.
The paper itself is disclosed.
Yes, let us see.
My lord, Monorama Naik.
3 eyewitnesses in this case.
7.
7 eyewitnesses.
Yeah.
Okay, yes.
Monorama Naik, who is the wife.
Item statement has been recorded.
Madam, relevant person, my lord. ସନ୍ଧ୍ୟା 5:30 ବେଳକୁ ମତେ ଫୋନ କରି କହିଲେ କି ଛଚି ନାୟକ ସୁନ୍ଦର ନାୟକକୁ ତାକୁ ବାପା ଗଙ୍ଗା ନାୟକ ଇଜ ପ୍ରେଜେଣ୍ଟ ପିକ୍ଚର ଓ ଝଟିଆ ବାବାଜୀ ଛକରେ ତା ସହିତ ପାଟିତୁଣ୍ଡ କରୁଛନ୍ତି। ସଙ୍ଗେ ସଙ୍ଗେ ମୁଁ ଏବଂ ମୋର ଶାଶୁ ଛକକୁ ଗଲୁ, ଦେଖିଲୁ ଯେ ଏଇ 3 ଜଣ ଆସାମୀ ମୋର ସ୍ୱାମୀକୁ ଜିଆଇ ପାଇପରେ ତାଙ୍କର ମୁଣ୍ଡକୁ ପିଟି ଦେଇଛନ୍ତି, ଯାହା ଫଳରେ ମୋର ସ୍ୱାମୀ ତଳେ ପଡି ଚିତ୍କାର କରୁଛନ୍ତି। ଆମେ ଶାଶୁ ବୋହୂ ମୋର ସ୍ୱାମୀକୁ ରକ୍ଷା କରିବା ପାଇଁ ଚେଷ୍ଟା କଲା ବେଳେ ସେମାନେ ମୋର ଶାଶୁକୁ ସେଇ ପାଇପ ରେ ପିଟି ଦେଲେ, ମତେ ମଧ୍ୟ ମାରିବା ପାଇଁ ଗୋଡେଇଲେ।
ଶାଶୁ ନାଁ କଣ?
ମାନେ ଶାଶୁ ନାଁ ହଉଛି ପାର୍ବତୀ ନାୟକ।
ପାର୍ବତୀ, okay.
Parvati Naik also statement is there. Parvati Naik also stated so. Same thing.
Same statement has been recorded, but she is not witness.
She is injured witness.
Eyewitness and injured witness.
My God.
Yes.
And steel pipe also seized from the present petition. In which pipe they were assaulted, it was seized from the present petition.
Charge sheet filed?
Charge sheet submitted on 23/12/23.
23, 12/23, okay.
Well, the weapon has not been seized the present petition.
These counts are there, how to?
Also, see why the incident occurred here. The deceased was sitting by the side of a shop room. He was being intoxicated, he was sitting there. See, ରାସ୍ତାରେ present petitioner ଗଲା ବେଳକୁ ତାକୁ slang use କରି କହିଲେ ମାମୁ ମା କୁଆଡେ ଯାଉଛୁ? ଇଏ ତାକୁ retaliate କଲେ। ସେ ଉଠିକି ଆସି ଗୋଟେ ଜାବଡ଼ା ଦେଲା ସେ ଲୋକ present petitioner କୁ। ଜାବଡ଼ା ଦେଇ ସାରିଲା trying to justify the no. Not the motivation of it.
Only trying to tell you what is the reason why you are doing.
The
That's what your case is.
my
What is your case?
my submission is motive is not there for the offences. Out of given sudden provocation, this incident has been occurred. Against the present petition, we will also see the FIR. Last part I am reading a lot.
Yes.
ତାପରେ ଛଚି ନାୟକ ପାଖରେ ଥିବା ଜଳଖିଆ ଦୋକାନରୁ ଗୋଟେ ଚୁମୁଟା ଆଣି ସ୍ୱାମୀଙ୍କର ବାମ କାନକୁ ଖାଲି ଖୋଦି ମାରିଲା। ତା ମାଡରେ ସ୍ୱାମୀ ରକ୍ତ ଯୋଡିଗୁଡି ହୋଇ ସେଇଠାରେ ପଡିଥାନ୍ତି। ପାଖରେ ଥିବା ଅନ୍ୟମାନେ ମୁଦାଲାମାନଙ୍କ ଭୟରେ ଯିବାକୁ ସାହସ କଲେ ନାହିଁ। ଛଚି ନାୟକ injuries.
Assault by means of the presentation the rod to the head, my lord, because his cerebral injury is there. And my lord,
What is the case? Yes, my lord, the case has been committed. Not a single witness has been examined. I am instantly custody for more than 1 year. And let the eyewitnesses be examined preferentially.
that disclosure statement and seizure is there.
The petitioner is adjudged to 63 years. And the two sons are of the men accused persons are also in custody, Lord. I have a handicapped daughter. Nobody is there. Any Indian commission will be present petition of
Eyewitness account is there, medical evidence is there, 27 is there. No, and so many things are there, how can I?
But the liberally I can't do what is there in the inside the custody for more than a year.
Let at least the injured witness be examined. Why? He's injured eyewitness. That's another problem for you. Madam, the petitioner is agreed by the order dated 16/2/2024. Plea has been rejected. Allegation against the petitioner is found. There are as many as 7 eyewitnesses to the occurrence. The wife of the deceased, Parvati, is injured witness. Injured eyewitness. Injured eyewitness. The counsel for the petitioner submits that the petitioner is a senior citizen of 62 years of age, and 2 of his sons are also in the custody in the present case. The petitioner has a handicapped daughter to be looked after. Therefore, he, apart from the merit, he submits that on sympathetic ground also the petitioner is entitled to bail. I am not inclined to enlarge the petitioner on bail on the aforementioned grounds. Since there are 7 eyewitnesses in the occurrence, the medical evidence is also very clear that the deceased has certain head injury. I am not at this stage I am not inclined to enlarge the petitioner on bail. However, liberty granted to the petitioner to renew the bail plea after the recording of evidence of at least the injured eyewitness, and the trial court is directed to
These are informant Monorama and Parvati. Monorama and Parvati.
and injured eyewitness Parvati and informant Monorama. The trial court is directed to examine the evidence of record the evidence of these two witnesses preferentially over all other witnesses. With this observation, petition. Yes. Yes.
Our offense under section 498 306 of our IPC, my lord. Petitioner in custody since 26/4/2024, my lord.
26/4/23.
24, my lord.
Okay.
Charge sheet has already been filed, my lord. Cause of death, my lord, suicidal hanging, my lord. Marriage was solemnized 12 years of occurrence, my lord. The male child was born, my lord. Thereafter,
Charges of 31st/8/2024.
23.
24.
31st.
8.
Acha.
Rejection order is 652.
Yes, I see. Is there anything?
Anti-mortem hanging, but only 3 witnesses statement was recorded under section 161.
One evidence of one.
Or one villager who is the independent witness.
How she died hanging? Okay. Yes,
That one independent witness, my lord, is Ajay Pati.
who was the husband?
My lord.
Yes.
ଆମେ ମୁଁ କି ଏଇ ଯେ ହରେକୃଷ୍ଣ ପତିଙ୍କ ଘର ଆମ ଘର ପାଖରେ ଅନବରଳି ଗ୍ରାମର ବୈଷ୍ଣବଚର ବାରିକ ଝିଅ ସଞ୍ଜୁଲତାକୁ ଆମ ଗ୍ରାମର ଗଣେଶ ପ୍ରସାଦ ପତିଙ୍କ ପୁଅ ହରେକୃଷ୍ଣ ପତି ପ୍ରେଜେଣ୍ଟ ପିଟିସନ ପାଇଁ ବୈଦିକ ରୀତିରେ 12 ବର୍ଷ ବି ବିବାହ କରିଥିଲେ। ବିବାହର 1 ବର୍ଷ ପରେ ସଞ୍ଜୁଲତାର ଏକ ପୁଅ ଜନ୍ମ ହେଲା। କିଛି ବର୍ଷ ଦୁଇ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ଭଲରେ ଚଳିବା ପରେ ହରେକୃଷ୍ଣ ପତି ତାର ସ୍ତ୍ରୀ ସଞ୍ଜୁଲତାକୁ ବାରମ୍ବାର ବାପ ଘରୁ ଟଙ୍କା ଆଣିବା ପାଇଁ କହୁଥିଲେ, କିନ୍ତୁ ସଞ୍ଜୁଲତା ଏହାକୁ ବିରୋଧ କରିବାରୁ ତାର ସ୍ୱାମୀ ତାକୁ ମାରଧର କରୁଥିଲେ। ସଞ୍ଜୁଲତାର ଘର ଲୋକ ବହୁତ ଥର ହରେକୃଷ୍ଣ ପତିଙ୍କ ଘରେ ଆସି ବୁଝାବୁଝି କରି ଯାଇଛନ୍ତି, କିନ୍ତୁ ସେ ନ ବୁଝି ସଞ୍ଜୁଲତାକୁ ମଦ ପିଇ ଆସି ମାରଧର କରୁଥିଲେ। ବହୁତ ଥର ସେମାନେ ହରେକୃଷ୍ଣ ପତିକୁ ଟଙ୍କା ବି ଦେଇଛନ୍ତି। ଏତିକିରେ ସେ ଶାନ୍ତି ହେଉନଥିଲା। ପୁନର୍ବାର ସଞ୍ଜୁଲତାକୁ ପିଟାପିଟି କରି ମାନସିକ ନିର୍ଯାତନା ଦେଉଥିଲା। 24/4/24 ରାତି ପ୍ରାୟ 11ଟା ହେବ ଆମେ ଖବର ପାଇଲୁ ଯେ ସଞ୍ଜୁଲତା ଦୌଡ଼ି ଦେଇ ଆତ୍ମହତ୍ୟା କରିଛି। So night at 11 midnight, my lord, that the petitioner must have been present. No one is
That you were not present, or she bolted the door from inside.
No, she committed suicide behind the back of the house.
Those part of the evidence.
From evidence, something that is my lord of spot. Maggot, check it up.
they look smart.
Why don't you prepare properly from? That is proper.
This is no way. And the renewability.
Let it come next week. I will supply the. Prepare and come next week. Doing at least you tell me something. I have tried.
Don't grant it. Like that, I can try to do something.
And next week,
Unless you ask it how they right, you tell me.
and next week.
Unnecessary, renewability. Right on.
Neither murder.
Petition rejected by the order taken, 6/5 whereby his bail plea has been restricted.
Otherwise, suffered cancer.
Subsequent thereto, the charge sheet has been filed on 31/8/2024. Since the bail plea of the petitioner was rejected at the time of during the investigation period, and subsequent thereto, charge sheet has been filed. In the changing circumstances, petitioner should approach the trial court by renewing the bail plea. If such bail plea is moved, the same shall be considered on the basis of the material available on material which form part of the charge sheet. With this observation, petition is disposed. Yes, next.
21. May I please your honor? The petitioner is in jail custody from 3/10/2023 for commission of alleged offence under section 363, 366, 376 2N IPC, read with section 6 POCSO Acts
Yes.
Charge sheet already been submitted, sir. Two witness already examined in this case.
Yes.
The victim and his mother already examined in this case, sir.
Show me the evidence. If you have, do you have the evidence? Of the victim? Well,
I have filed the evidence, the certified copy before your honor.
yes.
By page number.
Where is that? Yes, depositions are there. You just read it. Yes.
मतलब deposition of
Sir,
Once-
deposition, sir.
No, deposition there. See, this is the
deposition copy is not with me. You do not see me that 160.
mother and
His mother and the victim already examined.
victim. Yes. Informed his father. The victim is yes. I know the who is my co-villager. The allegation for about 8 months ago on the 11th date for 6 p.m. When I had to attend the call of nature, he told me that he is in love with me and want to meet me and took me to the backside of school and kept me in the thereafter took. What is the age of the victim? In the evidence, it is not written.
But 16 years, man.
16 years.
Big data birth is
Petitioner is 20 years. Your honor, petitioner is 20 years and victim is 16 years.
See, the evidence is recorded, nothing is written in there. Trial court also don't write how to get it. Only the name.
Your honor, medical opinion is also nil in against the petitioner, sir.
No. Medical evidence is my lord that the girl was pregnant at the time of examination.
No, sir. No, sir. Absence of
What is the benefit we are going to get out of this evidence for the victim? See, victim has supported the prosecution.
yes, sir.
Then,
Sir, victim, what he has said in this evidence, sir,
yes, he has completely supported his case of conviction. He has supported, both of the witnesses have supported the version. It is recorded on 15th May, rejected on petition is agreed by the order dated 19/4/2024, whereby his bail plea has been rejected. Subsequent thereto on 15th May 2024, the evidence of the victim and the mother of the victim has been recorded on 15th May 2024 as PW 2 and 1 respectively. Since the evidence has come on record, the subsequent to the rejection of the bail plea, petitioners shall renew the bail plea before the trial court on the changing circumstances. If such bail plea is removed, the same shall be considered on the basis of material available on record. With this observation, the petition is disposed of. Yes, next.
22.
May it please your lordship. My lord, the petitioner is in judicial custody since 9th May 2024.
9/24. Okay.
9 May 2024. The seized article is, my lord, ganja 9 kg of ganja and less than commercial quantity. My lord, there is no criminal antecedent.
Where is the recovery?
9 kg of ganja.
9 kg.
Yes.
9 kg granted. Subject to
Subject to
yes. 23. Custody which is 9/5/2024. Okay, 9 kilo ganja. Yes, sir.
Please, your lordship. The state took time to verify, my lords, as to when the charge sheet was filed last of
the charge sheet used that to do the investigating officer has signed the charge sheet. Yes. That is signed the charge sheet on 25/2/2024, but it was presented on 26. And the 180 days over on 25th itself.
Ask from the
Sessions Court, I have sought for a report. Let us see the report. What does it say? Report. Have you seen the report, sir? The report is, he has come to do the report. I am passing over, just read it so that you can access.
report has come. नहीं अरे हमारा ओरिजिनल फाइल दिया अच्छी just check it if the report I'll you so that you can access easily. Okay, basically log report. Oh, 3, 4.
Nowadays they always give long report.
They can dispose of the matter in the writing mismatch. Huh?
24.
Mr. Marty, you must read it. Huh? Yes.
Under NDPS Act, 200 gram brown sugar.
Yes.
Both are in custody since 34/2024.
30,
34/2024.
30, Kirichi.
Again,
Kirichi 24.
again.
She is there.
Yes, brown sugar.
200 gram, huh?
Yes.
My lord, petitioners have no criminal antecedents also.
You have the CD.
Now shooting reached. Yes, Lords.
Yes. No antecedent.
No criminal antecedent. They actually on the very day, both the petitioners were going to Nayagarh for purchase of my lord, furniture for the daughter's marriage. On the way, one of the friend of the petition number 1 gave them one jolly bag to hand it over to his relation. And on the way, they were trapped. One like the friend of
has 2 antecedent.
Huh?
Sachin had 2 antecedent, but not on our NDPS Act, but 2 antecedent is there.
Not similar.
Not similar.
Yeah.
And 200 gram.
Rina Pradhan is the mother of the petition number 1.
Against the Rina, there is no antecedent.
I'll go and Rina.
Madam.
Rina, unless.
It's also not used. 200 gram is used for the purpose of self-use, madam. That is not a selling.
No, for which he has been trapped. It is not for consumption.
No,
Personal consumption.
That's the problem.
Also,
minor that 9 gram, 10 gram.
No, that I gave. Therefore, I got
200 grams. That is the fact, my lord. I cannot improve it.
That's the problem. That lady I will grant, and so far as the section is concerned, petition number 1 rejected, and the lady petition number 2. The petitioners are in custody from Kirishi Chari allegation against the petitioner from there is a recovery of 200 grams of brown sugar from the possession of the petitioners. The petitioner number 1 has antecedent, although not similar kind, but he is involved in 2 cases. Petitioner number 2, who is the mother of the petitioner number 1, is a 48-year-old lady, and what are the evidences of petitioner number 2 basically? Yes, petitioner number 2. What are the allegations?
My lord, it was recovered when they were going on the.
Who was holding? Who was holding?
Holding, my lord, it was recovered from the car. From the Tata AC vehicle.
Wait.
They were doing.
Specific evidence against
No specific.
let us see. I'm trying something to distinguish the role of both of them. Something has to be written. Tell me something so that I can write that part. To distinguish the role of the petition number 2 from 1. Just check it up. Some sentence, somewhere you pick up and tell me so that I can.
Inside the seat, mother was sitting there.
Mother was sitting.
And polythene pouch was there.
It was
who was sitting in the car driven by the petitioner number 1. Petitioner number 1. Ms. Jana, the counsel for the petitioner, submits that the petitioner number 2 had no clue regarding the the contraband being kept in the car. She was only accompanying his son, accompanying his son. Regarding head to the aforementioned facts and period of custody from 30th of April to 2024, and the fact that the petition number 2 being a lady of 48 years of age, without having any criminal antecedent, I'm inclined to enlarge the petition number 2 on bail. However, insofar as petition number 1 is concerned, the bail plea of his bail plea is rejected at this stage. At this stage. Yes.
Okay. 25.
The lady, why should the lady be there?
No, seriously. Because I'll actually recover from the petition number 1.
Petition origin constitute. I make you pardon. Yes. In item 23.
23.
Which your lordship passed over. The learned special judge has only sent a copy of the order sheet dated 30th of August 2020.
He doesn't say anything about when it was submitted and
nothing.
By writing so many.
It is just a copy of the initial order sheet dated 23/8/23.
Is all facts, huh?
Yeah, order sheet.
My lord, passport.
Your lordship may see the.
The idea, see what had happened, you must understand. On 25th, 180 days over.
My lord.
I have prepared the charge sheet on 25th, no problem.
My lord.
But it appears that he is present on the next day. Therefore, the magistrate gives a seal and writes on 26th. So therefore, I sought a report from the court, trial court. Trial court writes so everything except that.
He doesn't write anything. He's
my lord, it is a fundamental right. The right of the accused it is coming under Article 21 of the Constitution.
If it is not filed within the charge sheet is not filed within 180 days, you tell me, shall I leave him?
No.
Taking that the charge sheet is filed on 26th, beyond 180 days.
26 is admitted because when the PO has signed then it is beyond 180 days. My last officer also stated that he is the entitled. Only that the signature, whether it is 25 or 26. And my lord,
that is what the report should come from the court.
Yes, that my lord, signature of the PO is my lord there. 26. But it was presented before the PO on 26, though it was charge sheet was submitted on 25.
Then go on, he is entitled.
He is entitled, my lord, but only that, my lord, in this regard, my lord. One judgment is there, my lord. That is the recent judgment. That CBI versus Kapil Wadhawa.
Yes, so.
Take a picture. My lord.
That is ED versus Kapil Wadhawa.
And CBI versus.
So,
only one copy I can see. I have marked that.
Well, it is clarified. The special judge himself writes that he received it on 26/2.
No, 26/2. My only fact is that.
Where is it? What is it? Who received the letter? What is this then?
What is it?
All fairness and the preliminary charge sheet.
It is
also received in 20. What do you say? He has admitted that on 26.
26 is not disputed.
Yes.
26. Then my lord can say that document, the last part. My lord, I have.
What do you want to say here?
My lord, only that reason that if the bail application was filed before filing of charge sheet, then his individual right is.
He has filed when you filed the.
On the 26th. When he has filed, if the charge sheet was filed before filing of that bail petition, then he is not entitled. If bail petition was filed, if charge sheet was filed after,
I understand.
then he is entitled.
No, if they filed in the morning of 26, they're entitled.
Yes, my lord, they're entitled before filing of charge sheet. Well, when the magistrate has put signature, when they are.
Time is not there. Anything which tilted in favor of the accused has to be given to the benefit of the accused. You tell me then.
Para 50, their lordship say, you are relying upon this, then you have to tell me. You tell me that after the charge sheet is filed, if they move the application, they are not entitled.
Yes.
That's what their case is. And you tell me the timing. That both the things happen.
My lord, that time you lordship may call from the district session.
Yes, see, I will tell you one thing. I will tell you one thing. The magistrate receives the charge sheet on 26th. He doesn't write the time.
No, he has not read.
Then how will you derive it? Don't say that it is filed in the evening.
Time is because digital e-filing or something is there, my lord. The time is there. Because before that, if charge sheet was submitted after, petition is not individual right. And that is a because my lord, earlier my lord, in advocate case, my lord.
Nature of the charge sheet filed on for that's it. Not filed within the meaning of notice of trial.
Well, also the simple judgment which will be rendered is lazy.
To carry on further investigation. The character is given lead to the conclusion it is after the investigation leading to the filing of the final form from source. Already contemplated from source. A court will tell you serious.
Yes. My submission, my lords will look at paragraph 50 of the judgment which my learned friend has filed.
Paragraph 50.
Yes.
Yes.
The original Bhagavan. The last line, my lords will see. The court writes, in other words, the very moment.
No, which paragraph only?
50.
No, this only 25 paragraph. Kapil Varma?
Yes, ED versus Bhagavan.
It is CBI versus
CBI versus Kapil Vadwan.
set of 2024. It is 2024.
It only says that if you don't move the application, the rights are there.
My
Rights in this. That is what it says.
that is
And they move the application. That's what sounds. They are fine. Well, on 26 is both the things have happened. Yes.
Mind that petitions are always filed in the first hour. They are taken up at 2 p.m.
And the trial court they keep on waiting, counting.
Petitions are 12 o'clock.
Yes.
And since at para 50 the court writes last sentence, the very moment stipulated 60 of the 90 day remand period expires, indefeasible right to default bail accrues to the accused.
Yes.
One of the charge sheet is dated 25th March. It is placed before the
What is the recovery in this case?
recovery of ganja
768 kg.
kilograms.
And my lord, earlier, my lord, in the Rabindran case, that date was excluded. Date of remand, it was excluded, counting then 180 days. Now, my lord,
Shall I send it to the trial court by recording everything and we will see the time and pass the order?
You will not be able to see anything.
I don't know. He may have had the timing, I don't know. I'll record everything and the trial court has to release. I'll say that he shall release if it is presented prior to the charge sheet is recorded.
Then my submission is this. If everything is to be done by the trial courts, then my lords, having superior courts, my lords, and having some
Not meant for bail.
no,
We are doing it because trial courts are not doing.
I'm not asking for
And now we are converting the Supreme Court to a bail court because of this article.
my lords. I'm not asking for bail. What I am saying is,
The factual verification, see, he is raising a point by relying a 24 judgment. And this factual verification has to be either done by the trial court or I'll have to call for a report. Once again, if I take cognizance of his judgment,
appropriately, my lord, I think your lordship should call for a report.
I'll call for a report then. I'll call for
Your lordship sends it back to the trial court.
Okay,
Again before your lord.
all right, that exercise the trial court will do and I'll call for a report.
Let the report be called for, your lordship will post it to the fifth.
Yes, right now. Petitioner has moved the present application for grant of bail only on the ground that he accrued a right under the statute, provided under section 167(2), for grant of bail. The matter was taken up for hearing on 17/9/2020. The following order was pursuant thereto, no, 17, no, 2024. Pursuant thereto, the Sessions Court, which Session Court? The District and Sessions Judge Malkanagiri has submitted a report. Perusal of the report reveals that indeed the charge sheet was charge sheet numbers, the charge sheet number 71 was prepared by the investigating officer on 22/2024. 2024. However, the same was submitted before the court on the next day, that is on 26/2/2024. By that time, the statutory period of 180 days for filing the charge sheet had already expired. Mr. Devasis Panda, Lieutenant Counsel for the petitioner, submits that the statutory right accrued in favor of the petitioner to be released forthwith accrued on 25th evening, as 180 days was completed on that day. Therefore, on 26th February 2024, it was inevitable on the part of the trial court to release the petitioner under the statutory commands of the provisions contained under section 167(2) for CRPC. At this stage, Madam Counsel for the states relied upon a judgment of the Supreme Court reported in 2004, 3 SCC 734, the CBI versus Kapil Wadhwan and another. He has emphasized para 38 and 39 of this agent, which he says under 38, 39. Relying upon the aforesaid judgment, Supra, Badhavan Supra, the State Council submits that if the application under 167(2) is presented prior to the submission of the charge sheet, then the same could have been allowed. However, once the charge sheet is laid down, the right to avail the remedy under 167(2) ceases. Therefore, he submits that it has to be ascertained as to whether the petitioner had indeed moved the application on 26/2/2024 prior to filing of the charge sheet or not. In this regard, Mr. Ponda, Lieutenant Counsel for the petitioner, submits that this court can seek a report in this regard from the court below to ascertain this fact. However, he says on instruction that in fact the petitioner had filed the application under 167(2) prior to the filing of the charge sheet in the first hour itself. Therefore, in fact, therefore he submits. In fact, no inquiry is required to be conducted in this aspect. Still, he has no problem if a report is called for. Since the statutory right on the basis of which the petitioner was supposed to be released on 26th February 2024, immediately after expiry of 180 days. There is an urgency attached to the same. Hence, the trial court is directed to furnish a report forthwith regarding the aforementioned. Please the matter on 3rd.
With the time schedules. With the time schedules.
Time settlement.
I learned from why should I say time schedule? I know it doesn't normally that there is no time schedule. Time schedule would have been there in the trial court would have been written in the 26th at sometime. There is nothing there. I'll take it. It is filed in the evening.
In a brown sugar case, the district session judge, he has mentioned the date as well as the time, that is 11 p.m.
But where it is not written, that's the whole facility.
Your lordship may keep this to the 5th, my lords. One other matter your lordship has adjourned to the 5th.
Right, very urgent matter, 3rd, I'll do
5th, 3rd I am not there.
Okay, 5th. See, because this is not filed digitally, I must tell you.
It has never been filed digitally.
Charge sheets are not filed digitally.
Well, petitions are not filed digitally.
Petition, when first hour you might have filed. Suppose he has filed at 2 o'clock. Suppose he has filed 2 o'clock.
Before
How do you
submitted.
How do you know?
Because he would clarify when he has put his signature.
It can be clarified. But there is nothing, time is not there.
No, time he has not mentioned.
Then why will you consider that the charge sheet is filed prior to lunch? Why?
Practice is that CI is.
No, I will not go by practice. Since in the charge sheet there is no time mentioned, even if he filed at 2 o'clock or 3 o'clock,
That is, but the charge sheet is.
No. When the magistrate is received.
Magistrate of 26. So what time he is received?
What time?
Madam, that is not effective.
That will never come because he is not written there. He is not written there. So therefore, this is filtered into the accused and it has to go to.
Otherwise, madam, he is entitled. Only that my submission.
That's the problem. Magistrate should have written it.
There lies the problem that a statutory right is sought to be shackled by the amount of the narcotics. Had it been 20, the amount is nothing. Had it been 20 kilograms, my learned friend would not have known.
My lord, brown sugar says.
They were irrespective of whatever the quantity.
It's not a matter.
What you all should be saying to us that courts are being converted to bail courts. Why are they being? That is because the courts are not doing the rights which are.
Brown sugar
Everything would have been solved.
brown sugar was seized more than 2 kg something. In spite of that, the magistrate has that the session court has written that at 11 p.m. he was received. So he was entitled to bail.
Very strictly. Otherwise, the statutory right
It is coming under the Article 21 of the Constitution. This right is coming under all the
Article 21. What, fifth?
statement.
Yes. What about the other matter?
Which one?
Yes,
That is same.
Same track. Same track. Okay. There is that photo. For parliament. One good reason. Yes. I'll just come back.
It is the duty of the court to implement the action.
Case under section 376(2) and 342, 506 minor.
Sorry?
342, 376(2) and 506 minor.
Yes.
But the petitioner is in consortium, my lord, 28/11/2023.
I'm sorry, 20?
28/11/2023.
28/11/23. Okay.
My lord, the victim is a 19 years girl, my lord. The allegation in the FIR and is a 164 statement, my lord.
164 read.
My lord, 164, my lord.
164. Do you have the CD?
ମୋର ନାମ ମୁଁ 19 ବର୍ଷ ଅଟେ। ମୋର ଭୟ ନେଇକି ଗତ 12/11/2023 ରାତି 8ଟା ସମୟରେ ମୁଁ ଆମ ଘର ପଛପଟେ ବାସନ ମାଜିବା ପାଇଁ ଯାଇଥିଲି। ସେହି ସମୟରେ ଆମ ଗ୍ରାମରେ ହିମାଂଶୁ ଭୋଇ ଆସିଲା ଏବଂ ମୋ ମୁହଁ ବନ୍ଦ କରି ମତେ ଜୋର ଜବରଦସ୍ତି ତା ଘରକୁ ଟେକି ନେଇଗଲା ଏବଂ ମୋ ଇଚ୍ଛା ବିରୁଦ୍ଧରେ 900
Committed for offense under section 376(2) and 328.
Yes.
350 for B. Read by section 5 of the Odisha Prevention of Witch Hunting Act.
Yes.
The victim girl is 25 years. The age of the victim girl is 25 years.
Yes.
Charge has been framed.
That has been filled. Okay. Okay. What are the allegations?
allegations is serious allegations.
Tell me.
See that. ମୁଁ ଅନନ୍ତ ପ୍ରଧାନ ଗ୍ରାମ ମଣ୍ଟିଆଲ ଜଳସର ବୋଲି କହିଥିଲି। ତ ଅନନ୍ତ ପ୍ରଧାନ ମତେ 2 ଦିନ ପରେ କମରଦାକୁ means first he discussed that she was lobbying to some person, he was not coming to her, but that only one of that villagers lady said that if you go there and meet him, he will make some things that he will come to you.
Yes.
But that only we discussed with him.
Right.
ବିଜୟ ବେହେରା କେମିତି ତୋ ପାଖକୁ ଆସିବ ମୁଁ କହିବି।
Okay.
ତାପରେ ମୁଁ 2 ଦିନ ପରେ କମରଦା ଏରିଆକୁ ଯାଇ ଅନନ୍ତ ପ୍ରଧାନ ସହିତ ଭେଟ ହେଲି। ତାପରେ ଅନନ୍ତ ପ୍ରଧାନ ମତେ ତାଙ୍କ ସହିତ ଦୀଘା ଯିବା ପାଇଁ କହିଲେ। ମୁଁ ତାଙ୍କ ସହିତ ଦୀଘା ଗଲି। ଅଳ୍ପ କିଛି ସମୟ କଥା ହେବା ପରେ ସେ ମତେ ଥମ୍ସ ଅପ୍ ପିଇବା ପାଇଁ ଦେଲେ ଏବଂ ଅଳ୍ପ ଗୁଣ୍ଡ ଔଷଧ ଦେଇ କହିଲେ ସେ ଔଷଧକୁ ଥମ୍ସ ଅପ୍ ରେ ମିଶାଇ ପିଇଦେବୁ ତାହେଲେ ତୁ ଭଲ ପାଉଛୁ ସେ ଫେରି ଆସିବ, ତୁ ଯାହାକୁ ଭଲ ପାଉଛୁ ସେ ଫେରି ଆସିବ। ତାପରେ ମୁଁ ସେ ଔଷଧ ଥମ୍ସ ଅପ୍ ରେ ମିଶାଇକି ପିଇଦେଲି। ତାପରେ ଅନନ୍ତ ପ୍ରଧାନ
in this witness, PW8 and PW13 are the eyewitnesses. They became hostile. And as far as
when the evidence of those witnesses were examined?
Prakash Behra, running page number 68, Your Honor.
68. Yes.
He
68.
was examined on 20th March 2024.
In January 24. Yes.
He stated that he heard about the occurrence from the villagers.
Yes.
In para number 2, from
PW4.
and
PW4. We are talking about PW4.
PW8.
PW8, sir.
Okay. PW8. Okay. Okay.
PW13, one Anil Kumar Sahu, which is running page number 79 of the deposition copy.
What do you want to say? What he has said?
Sir, in his cross examination, para number 6, he stated that after informing my co-villagers about the incident, I, along with the deceased mother, Darshini Khamari and Mili Khamari, and other 5-10 villagers went to this spot.
What is your name?
Sir,
What is your name? What is the name?
my name is Chintamani Sahu, sir.
Chintamani, yes. The informant that has my co-villagers standing.
Dr. Seven also was admitted to one and went there and
behind the
extra recovered from the
I heard from the villagers that the accused has killed these. Yes. And this PW8 has
yes
turned hostile.
Yes.
And PW13 is also hostile.
He became as a hostile in cross examination para number 6. He stated that
Yes.
after informing my co-villager about the incident, I, along with mother of the deceased Darshini Khomari, Mili Khomari, and other 5-10 villagers went to the spot. He also the hearsay witness, sir.
And what is there? These two witnesses have said that they haven't seen it. They have heard it from the villagers.
Obviously, but in the one substance statement, they that we have seen all
That's
this.
right, but it was
After
not.
that,
The prosecutor is confronted, but nothing could be elucidated from there.
And what else is there? X was recovered when police with the witnesses gone there, and from the bushes that X was recovered in present of
The recovery witness, who is the recovery witness? Should when the recovery proof. Your two eyewitnesses have gone.
Yes.
They have not supported you. And what else? The prosecution's biggest strength is eyewitness. Those witnesses have gone. Have you examined all the evidence?
No.
Because see, the evidences were recorded in January 2024 and in April 2024 the bail application is rejected.
Yes.
If the eyewitnesses have not supported, what else you have? Why should he be inside the jail? He's already there in jail since November 2022. I'll put it on 5th, you get ready.
Manoj Kumar Pradhan and Mahavir Pradhan. These two.
I'll put it on 5th, you get ready. Because he has filed all the evidences here. It has to go through. I'll just hear it on 5th, huh? Because the prosecutor has to read it. Okay.
29.
Yes, sir.
Your Lordship, in item 29 is a CBI matter, Your Lordship. Republic of India has been made a party, Your Lordship. Here, CBI has to be made a direct party, Your
It's all
Lordship.
right. That's a long thing.
Mr. Naik.
That can't be a ground for now.
May please, Lordship. But this is a matter which had come earlier. But the entire case before Lordship is the alteration of condition of bail granted by the trial court. Bail has been granted. There is a condition. The condition is.
Which condition?
Yes, condition that Lord that is page 72, Your Lordship. Can we say?
72.
Yes.
Annexed?
Better.
Yes.
Yes.
It starts from 56.
Yes, sir. It's a long order because they are all matters are taken, not for me only. There are 20, 30 accused persons, all matters are taken together.
What is your name?
Sir, I am Indrajit Dey.
Indrajit Dey, okay.
He is a director. Page 72, Your Lordship says. Himself, Your Lordship says, one, we are only concerned with two. He shall surrender his passport before the court. He shall surrender the passport before the court.
Number 2.
Yes. What I asked for is, I went to the trial court, also asked for, the trial court said that I don't have power to change, so I am before the Lordships. The trial, what I have asked for is, and the reason I give the Lordships, why I have asked for, why I have asked for is that I will, whenever I go, I will, no, permission is the difficulty, my lord. I tell the Lordships what, that's the reason. Every time that permission asks for, obviously the same opposition what Mr. Naik will do now here, that I'm a flight risk, I'm a flight risk, I'm a flight risk, and it takes a long time. I tell the Lordships what I'm saying, that every time I go, I will submit my tickets. I will submit. In fact, I've already been permitted once by the High Court. Mr. Naik was approving that there's an address. I have given the order. I will submit my tickets. I will submit my detailed itinerary. I will submit my bill, and this will be submitted. The permission will not take, unless your Lordship direct. Every time I ask that, then within 7 days you decide. What in fact it takes 5 months to decide what he decided. And I came. But I tell the Lordship why I did this. But and your Lordship would also like to know what the case is all about me.
Like the flight risk thing is an apprehension or it is executed by your conduct?
By your Lordships? No, flight risk conduct means that flight risk is the standard from apprehension of the city in the sense
on apprehension.
Because the court has already negated that.
Have you ever absconded or
no, Lord, I have been in fact admitted to this court. No, I tell the Lordships what is happening. But I am a 1,000 crore project in India, and I am ordinarily reside in India, but my wife and daughter and my father stay in USA. That's number one. And as well as only one daughter, 11 years old, as and when required, because what happened is, second is, I have a lot of investors from outside for which I have to travel. Now, question that my difficulty is that if I apply for, I have a requirement for my mother-in-law's is, but every time it takes a long time because of this. In fact, the last time it took 5 months, and in fact, I came before this court, and then this court elaborately said and granted me time because that was a temporary for 2 months.
Right.
Then thereafter, after 6 months, I come back, deposited my passport, and again before lodges. What I'm asking for is that kindly, Lord, I will every time, and is subject to always the court can impose condition that don't go this time. I have to, not most of the time I will in India because 200 average 200 days and I'm in India. But my requirement is such for England, it is a big project I'm going on. But my allegation against me to accusing which case where I tell lodges. I am an accused in a supplementary charge sheet. What happened, Lord, a cheat fund company was there. Following a FIR was lodged in 2013. In the cheat fund company, I am in a company of a big projects and a 2.5 crores was transferred from the cheat fund company to me in a bank transfer.
Okay.
Right. It is not that I am a cheat fund company at all. In a bank transfer, 2.5 crores was transferred. Is transferred to me. Not anyone also sees the entire Mr. Justice Sahu had dealt with elaborately. Also says, but judgment of pace growth. Sir, kindly see the earlier day, everything has been, see the same flight trace, everything has been said. Then I'll just not, it's a very elaborate order, but I'll tell you also take you only the relevant portions of the earlier order, whereby permission was granted. But now what I want to say that seeking permission granting is not possible always, but I will not that I'll go just like that. I will change, give my theory, I'll give my tickets. When I'm going, when I'm coming back, I'll give them a copy to
The problem would be the trial is going on.
The trial is going on a day. No, I will tell you losses. I will tell you losses. Trial will not wait for me. I'll tell you losses what. In fact, this court also found out there are 20 accused persons, 100 witnesses, and it's still awaiting. In fact, the court earlier observed how long it will take, God only knows. I mean, that's what the court, not the God only knows. The court said that it will take unusually long. Yes. There are 100 witnesses. Trial will never wait for me because the condition is that what is stage now? Stage is only the appearance of accused. Nothing is happening beyond that. 20 accused persons, as well as 20 accused persons and for appearance. Maybe you also see.
You do one thing, you go now when the trial will start, then we'll see.
Yes, you know what I will go and you will see. Yes, I will just go because of the requirement. I just, in fact, I want to go, you can go. You have to be here. May I pray, Lord, that your lordship may ultimately deal with me what sort of conditions, because that cannot be done by trial court. What sort of modification, lordship, there are no bill later. Lordship, I have made an IA. Kindly permit me for, I have asked for 3 months, you lordship, I have me 2 months time. Yes. Come back. That's what is, I'll keep it pending. Yes. I'll allow him to go for 2 months only.
Just
try to appreciate. Trial has not yet started.
Yes, your lordship.
So why should we let him go and come back? And going to
just pass over we might be misunderstood, your lordship, because the department files a reply in each and every matter holding investigator.
No, that's, he has filed an objection to the trial court. That is there on record. Same flight.
See, there are two things which we need to go today. I'm not going into the very subject. First of all, trial has not yet started. Okay. Second is earlier also this concession was granted to him, he went and came back.
Yes, your lordship. Yes.
Okay, these are the two things. On that basis, the IA can be allowed.
Yes, your lord. Your lordship may just pass over the.
That part, then we see how in 2 months again your lordship take it up.
Pass the order in the presence of Mr. Naik, your lordship. Mr. Naik is on his legs. I just require one pass.
Not in presence. So I thought I'm sorry. Very confident. No, very confident. I'm sorry, Lord, for my misstatement. I don't know why he said strong resemblance, Mr. Naik. I was all throughout thinking that Mr. Naik is there. He has Mr. Naik's associate or friend, but he looks so strong.
I will not allow this petition. I will just indicate that I am talking about the IA.
Yes, only I will also on 2 months' time, same conditions will also say, right? At page 124, I was allowed, my lord.
Where you show me when you were allowed.
Yes, sir. At page 124. Page 124.
124.
Sure.
This annexure.
Sir, that is part of annexure. That's part of annexure for the last page, Lord. That was the rest is earlier order. Right? I would have thought.
I'm taking it. Okay. 124. Huh?
Sir, I would spare copy today. So that's right.
So that while giving dictation, it will be easier.
Yeah, no.
124. This is the. This is Sahu. Okay.
So, in view of the lot of like this, everything is considered, the delay will be considered, anything concluded. In view of the foregoing discussion, the interim order dated passed by the learned special CJ and set aside because CJ might refuse.
Yes.
The original passport bearing etc. of the petitioner which has been deposited in pursuant to order dated etc. that 9/23 of the bill order shall be used in favor of the petitioner for 2 months to facilitate travel away subject to submitting itinerary travel schedule.
When did you left India and when did you come back?
Sir,
give the dates.
Yes, I
Left India.
so I just give a lot of the dates. Date here. I'll give a lot of the date.
And when you came back?
Yes.
I have been released.
ನಮಗೆ ರಿಲೀಸ್ ಎಲ್ಲ ಕೆಲ ಡೇಟ್ ಸರ್ ಆಗಿದೆ 25/6/2024 we came back and 25/6/2024.
24. Okay. You came back.
And reported deposit.
And when you left? When you left?
I'll just give that.
I will record that.
Yes. When did he go? And just yes. That's I came back and now we'll also keep it and thereafter we'll also decide what could be the modality by which the trial is not hampered, nothing hampered. At the same time, I do not have an impediment because of the
I record that time. Trial has not yet been.
No, trial has not. It will go acquaintance.
April 25th we left.
April 25th left.
25th April.
Yes.
24. Okay.
And 19 he came back but deposited 25th. Settled.
Yes.
Night.
Okay.
Yes, sir.
I'll pass you.
Yes, sir. Yes, sir. That's now order the IA, the matter remains. Matter will come.
Matter will come after 2 months.
After 2 months.
After 2
No,
months.
no, just after 2 months.
And I'll record that record that if you don't return, then this petition will be automatically dismissed if you don't report.
Automatically, but I will not stand for him if he doesn't report. He will, I will say that if you
Don't report to this court.
yes.
After 2 months, and we fix a date.
No, not report, but not deposit because not report means if you also direct that passport is with me. If you whatever conditions will also be I will have.
The same condition, whatever that earlier.
Whatever conditions. I love it. Grateful.
Yes.
Much obliged.
30. Yes.
My lord, in that case, my lord.
Exact date I give after 2 months because you 2 months and some day because once you pass the order 2 months and after 2 months sometimes because it will take time and you get visa and or whatever it takes its time. Yes. After 3 months rather. After 3 months. Yes.
Yes, sir. My lord, this is an application to question the entire proceeding on the ground of the compromise, my lord.
What compromise?
My lord, in the year 2011,
Offenses?
my lord, offenses under section 494, 376, 294.
No, but charge sheet filed.
My lord, charge sheet and
already case number. The case of 2011 manner. There are terms session style number 2015 manner. Perhaps NW issued and they filed another CRMC before this court. And that's the was to have been granted. For that is there is delay. And that has disposed of CRLMC 490/20. The dispose of the 20th, 3/20, my lord.
During the COVID time, my lord, they could not appear, my lord. They are residing, my lord. They are residing to that. It is, well, where are they? Let us see first of all. First of all, this, Mr. Oda, please ask the wife. Archana, who? Who's date you want?
27th to 28th of October.
28th of October, interim order earlier passed, shall continue till next date of hearing.
Great.
Thirty-two.
Time actually, na?
3 months later, who? Okay, agent. Yes.
Please, your lordship. This is the matter where. Yes, my pleasure, Lordship. This is the matter where the initial statement and the complaint doesn't disclose the probable offence against me and the nationalized insurance company. And the Lordship is pleased to issue notice to the OP1, the complainant. Please enter the appeal. Proceedings for state.
We want to proceed to be part of the file the complaint against the petitioner. But not 2 and 3 entry there with allegation that he has purchased a mobile phone issued with the opposite party number 2. Since he lost his mobile, the claim has not been what did you say? Status?
Complainant sufficient.
Opposite 3 refused and hence returned.
3 has refused.
One is the notice was issued to opposite party number 2 and 3. Notice insofar as the petitioner opposite party number 2 is concerned is sufficient. However, the opposite party number 2 has refused to accept the notice. Therefore, the notice on both the opposite parties are declared to be sufficient. Nobody appears for them. In the interest of justice, one more opportunity is granted to opposite parties. And leads to matter consequently. An interim order passed on 14/8/2024 will continue till November. Yes.
Yes. Lordship, this matter may be taken up after vacation. Lordship, I applied for a certified copy of the deposition. Lordship. Matter may be taken.
Monthly accounts for the petitioner seeks redeployment for revealing certified copy of what?
Deposition, Lordship.
Certified copy of for deposition to place on record. Needs to matter after November.
35 may I please, my lords. Yes. Lord, this is the case which was yesterday as well, my lord. My lord, connected matter is also there, my lord. 3341 of 2024.
What way? It is not in our assignment.
My lord, earlier this matter was heard, for which I had challenged that order. I mentioned, my lord. Yes. It is not.
What is this? Let me understand.
Yes. My lord, this is a small case, my lord. I'm here for the second round on humanitarian ground, my lord, or I'll not play something on merit manner. An order has been passed. No, my lord, MPW has been set aside, my lord.
Then what?
I have a very limited grievance. My lord, in my lord, 3341, second matter.
No, page 6, you see the prayer.
Page 6.
Call for record, cancel MPW. That's all. No, my lord, that order was passed in 1649, my lord. That is a disposal of case, my lord. That has been, prayer was allowed on 9/5/2024, my lord. 9/5/2024.
Yes. Now, what do you want now?
My lord,
You have moved 9.
my lord, at this stage, my lord, I have a limited prayer, annexure 5. The order has been passed, granting me, my lord, 6 installment. Any further installment, my lord, that will suffer.
No, that, yes, I remember.
My lord, because my lord,
You said it annually was cancelled.
that was cancelled.
Therefore, the court will.
My lord, taking into account the recent development that
Yes, he further submits that due to the due amount of rupees so and so, he could not pay.
annexure 5 is under challenge, my lord. A report है fast SG.
My lord, you have moved the application for trial court.
I have moved an application, and that application is at annexure 5 in the connected matter, my lord. So I have challenged that
Why have you come here?
my lord, only for some relaxation in that installment part, my lord. Limited waiver only for that.
I have not able to follow. I have allowed your petition.
My lord.
I said that you moved application for paying the amount of on installment.
My lord.
You moved the application. That was rejected.
No, my lord, it was not rejected.
What happened?
It was allowed, and the court said that you pay 1 lakh.
Evidence that you have filed another petition.
My lord, I have filed an application just for a relaxation time, my lord. Instead of 6 installment, your lordship.
Their application. That's what you said already, trial court.
My lord, after moving an application only, they have passed. My lord, under annexure 5, my lord, in the second application. That is, my lord, 3341. That order I have challenged.
That is not in our assignment.
Then, my lord, not sure.
You press that there.
My lord,
why have you moved this application? I don't know. What is your grievance here?
My lord, grievance is that, my lord, instead of 6 installment, any further installment.
I understood. How many times you sent for that? I have allowed the application saying that you move to the trial court for installment. You move the trial court.
Yes, my lord.
Trial court says that you have to give it within 6 weeks. 6
installments.
And you are agreed by that.
Yes, ma'am.
You say that no, I need 24 or 30, whatever.
Any further, my lord.
And against that order, you have filed another CRB. But why have you moved this petition? What is the grievance in this petition?
My lord, I have placed, I have not placed, it is on the report, my lord. I have not placed any IO, my lord. On the report of the that matter was before the court.
What?
Report of the, my lord, concerned trial court, my lord. That matter has come.
Where is that report?
In, my lord,
Flat C.
at flag C, my lord. The same order.
What does it say?
That this has been allowed for the 6 installment, and I have defaulted that, my lord. That is the order. On that report, my lord, so
Is since the civil judge, junior division come JMFC Mohana, district Gajapati, that is before this in Mahavatra.
Second, the connected matter 3341.
No,
3341.
that is go before this in Mahavatra. Okay. Continue. Has submitted a report dated 6/8/2024, informing this court regarding the default of making the payments by the petitioner, the present by the petitioner pursuant to the order dated.
Pursuant to the order dated lower court order, my lord, dated 29/6/2024.
29/6/2024. The present matter is listed today. The Mr. Mahapatra and counsel for the petitioner submit that pursuant to the order dated 9/5/2024, he moved the petitioner had moved an application before the trial court for making good the payments of 6 lakh rupees by By how many? By
24
by
installments.
24 installments, which has been turned down by the trial court. And trial court fixed up. The said order is essayed by the petitioner before this court in CRLMC number 3341 of 2024. The 24. Or he said 24. Since the said CRLMC 3341 of 2024 is listed before closing bench. The present the report please before this court. The report filed by the civil judge junior division come report dated 6/8/2024 filed by so may also may place before the court bench. With this observation, the petition will dispose.
36.
At a hearing as well.
Hearing response कौन?
At a strap case. Hearing complainant hostile. Now hostile hella parent sometimes against the appellant. They say that latest come for
So see will get it ready. You get it ready. Take soft copy, get it ready. I'll play
paper nahi. Paper nahi.
No, she will do it. She knows it. One to him, one to this court, and for one for you. Take it from here. Okay. Okay. List it. And list it November first week November. Yes. Meanwhile, you will prepare it. Okay. Yes.
37.
And I see you have defaulted in one matter. You argued, Mr. Ponda has argued and assured that he will file a written submission. Written submission hasn't come in an appeal. That's the reason I am not able to give dictation. What of that I have done, and that is still remaining. It is your report, not his report. I will not tell you. It's junior job. He should have done it. Yes. Take the number in which appeal you have not done. Okay. Yes.
My lord, this is an application.
37? Yes.
This is an application where I am seeking, I may be allowed to use my Demat account so that I can.
Yes, that Demat.
Now, my lord, see this.
You were supposed to get some. Yes.
Now I am able to get these documents which will indicate the Demat account and the connected. If your lordship sees Shipra Kumar first. Shipra Kumar. Shipra Kumar is petitioner number 1. So first holder name is Shipra Kumar. Or your lordship may see Vinod Kumar.
Vinod.
Vinod.
Yes.
At the top, the client ID number is 1069872.
Yes.
That is a Demat account. This is connected to the bank at the bottom level. Your lordship may come to the bottom.
Axis Bank Limited.
Yes. Bank account number so and so, and saving the account, the nature of the account is saving. Yes. If your lordship is Cipra.
This savings bank account number here.
Sir.
And this is the Demat account.
And if you also see now the Cipra. Cipra, in fact, petition number 1. Cipra client ID number is at the top, my lord. This is a different number from that of Vinod Kumar.
And savings is
the same. So in order to ensure transparency and to show my bona fide, my lord, I will submit the details of transaction of share from the National Stock Exchange before the learned court below. I will file a detailed bank accounts
by which the money goes to that account before the lower court, but you will not touch fixed deposit and deposit is there. My client is there, my lord. His statement may be recorded, my lord. If it defaults, my lord, if it does something wrong,
You can delete account, no problem. You can delete, you can trade
because what I'm saying, my lord, these accounts have not been frozen by the vigilance. This Axis account, saving account has not been frozen by the vigilance. So whatever is there, I'll make a fixed deposit and submit it before the court, my lord. Because the fixed deposit will fetch more interest, my lord.
My lord, so now they are submitting that they will, they can operate, they cannot. Because earlier, my lord, so on the last occasion, they had submitted that value of the Demat account will be deposited on the corresponding saving account, which they are given by memo. That has been freezed. So that can be done.
No, see, the savings account is not fixed.
That Axis Bank account, then I have to take the instruction.
That's the problem. See, Demat account, he will operate because he will trade that share, whatever you want to do. Whatever the money comes, it will transfer to this savings account. Savings account is not frozen.
How it will be, it will be a problem, my lord. So I will take instruction, my lord, so on basing on this.
And I give an undertaking, I will not operate except the money which comes by sale. I'll make a fixed deposit and deposit with the court, madam.
The savings account can be frozen.
No, if this, if it frozen, the money will not go, madam.
No, money will go, then you will change to,
I will withdraw.
Trade, if they trade the share in the Demat account, and it will come to the savings account, and they will retain not to withdraw anything from there.
That can be. The only thing I can do, madam, with your permission, I'll make that money in a fixed deposit and deposit in the court below. Fixed deposit will fetch more interest, madam. Because it is my confiscated.
See, Demat account you are operating, you are handling trading sale and all, and you get good money. Why if
that money will go to this account, madam. Unless I cannot have money cash from anybody, madam. Here I say, madam, the sale proceeding goes to this saving account.
And then from the savings account, you will take it and
they are accepted. And then the proceeding is there. Undertaking, my client is there, his undertaking can also.
Yes, I have said if you can transfer to the from Demat account when you come to savings account, you will withdraw and it will fix it.
Yes, madam. I will take instruction.
You take instruction and fourth and fifth. Fourth, keep it fourth. Now you understood what you say.
Yes.
See, Demat account you have frozen.
Yes, money Demat.
He wants that Demat account he will operate and trade.
Yes.
And the money generated from there will come to savings bank account.
This account bank account.
Yes.
And they will take away money and they will fix
And that fixed deposit in
the court. Deposit in the court.
So that the money is not,
Continue to be in possession of the property.
Earlier, their submission was that
I thought both the accounts are frozen. If you start allowing them to operate the Demat account, the money will straight away come to that account and it remain there. That was, but now things are.
My client is going to that extent that let them also freeze the saving account also, no problem, he is saying. But that way, no, let them take instructions.
Yes. Once it come to the savings account, because it is attached to savings account, whatever it comes, it will be frozen.
Yes. I have not touched that money. Repeatedly I am saying, my lord, with all benefitness, my lord.
Yes. Fifth, huh?
Fourth, sir.
Fourth, okay, sir. Password is there. Two password. Let us take one.
T.
39 adjourn. 39 interim order to continue.
Interim order.
38 interim नथला. I am the opposite party.
38.
Interim expire करिए. It was not continued from day to day.
Who is mentioned?
I understand one. Mr. Mishra must have mentioned. Jaus are vacation, but I have no objection. But interim order was not being continued from day to day. That's why that
When the interim order was passed? Nothing.
long ago. Now, ଏବେ କୋଉଟା extend ହେଇନି sir.
ନା interim order କେବେ ନଥିଲା?
How can as it is how?
Simply.
Fix ହେଇଛି କି date fix ହେଇଛି ନାହିଁ ଖାଲି after vacation.
40.
May I please, your lordship?
Yes, madam.
My lord, this is for crossing a paper dated 8/9/2020. The FIR filed by the sister-in-law, claiming that the will dated 2009 is a old one, and also, my lord, kindly see the FIR, my lord. My lord, the FIR, my lord, she said that.
Who is Pradeep Kumar?
My lord, he is the husband's brother.
Dilip's brother.
My lord.
Dilip's brother.
Dilip is his husband. He is our husband.
Dilip is the husband of Sujata, informant. And Pradeep is the brother of Dilip.
My lord.
Elder brother is Dilip, younger is
Yes.
My lord, the will was made by the father-in-law of Sujata.
Litigation is your manipulated the.
If this has been created after the notice is received in the suit, and therefore it's a fraud on court. I'm sorry. Let us.
My lord. My lord, kindly see the FIR, my lord.
State government councils on the process.
Kindly see the FIR, my lord. That is in page 7, my lord.
Yes, I'm there. Exactly there.
Page 7, my lord. That Keonjhar and also one of the beneficiary of the will, namely Hon'Ble Mishra, son of Pradeep Kumar Mishra, have made a criminal conspiracy in connivance with the staffs of the office of the district sub-register Keonjhar and
What is the property?
the property of Chakradhara Mishra.
It's a commercializing. Where from she is classified 1,60,000 per month as a rent.
Well, you will have brothers. Suit is
spending.
Why don't you study?
I have attempted.
Will not study.
Thanks. Because he's getting rent, my lord. Why is he have a partition suit? Yes, after getting the notice, this will have been fraudulent. Declare this suit. Everything.
Show me the suit filed by you seeking declaration that would be analytic under law.
My friend has.
You have filed the suit?
He has filed as complete thereafter.
In which my lord, the will has also been mentioned in Sibo deed. Sibo deed is also in the partition, my lord. Thereafter, in the evidence, my lord, in 2017, she has stated about the will. She has already stated that means she knew about the will in the 2017. After a long period, that is more than 11 years, she filed the stating that this person, my lord, the signature and communication of the executor mentioned on the will and also to be cross-checked and match as per legal procedure. The original records of the documents submitted by me as reference are available with the office of the district sub-register Keonjhar and the court of civil jurisdiction Keonjhar, which are to be utilized for the purpose. Then, my lord, the signature of the registering officer mentioned on the will is also to be verified. And as per legal procedure. Then, page 8, madam, under the circumstances, I would request you to make proper immediate investigation over the matter to reveal the truth and thereby protect the right.
If my friend has completed, I'll.
Yes, it is a registered will. What criminal case? You file a suit for declaration.
What has happened here in this case? If my friend has completed, then I'll start.
Yes, he says, I want to put now.
One forensic report is that the will is, the signature is not one and same. That for
Utilize that in declaration. That is why I am saying, you need to declare it should be. That is where every partition should.
that report was there in the CLMP. Therefore, this honorable court.
Please answer me.
Correct.
Where is this suit you filed seeking declaration? Have you filed or not? You will not file.
Is filed.
So you filed it. That partition should.
It's a partition suit.
But not declaration suit.
In that amendment was sought for, it was subsequently added. I was the conducting.
Seeking declaration there.
Yes.
Okay. And that court will take care.
That is taken care. So far as criminal.
Have you asked for rendition?
Madam?
Have you asked for rendition of account? In partition suit?
The receiver application was filed.
No.
Receiver application was filed.
You say that we are earning rental and all.
60,000 they are earning.
Then where is the rendition?
Receiver application was filed. It was earlier dismissed and now pending before the Illinois district judge in FF. And
You will not ask also rendition of account.
no, the applications are pending before for the appointment of receiver. But my point is the criminal intention. The criminal intention behind this creation of this will, that may be identified in a criminal proceeding. That may entire corpus file. Because after receiving the suit notice, this will was created. During the lifetime of the father filed a WS in the suit. He never said anything about the.
Have you said that I have not signed? Never said something and.
This will has not been brought to the knowledge of the court. After his death, all this new episode, this document was brought to the court's record. And I came to know such a fraudulent document is there. During the lifetime, father, mother, everybody was the defendant in the suit. They filed WS.
Father is no more now. No. Then
after this,
who becomes the criminal case that
totally it's a fraudulent document. Therefore, one forensic report is here. This arbitrate signature in the suit is not the signature in the will. That is one. Now investigation is going.
Suit is filed by the brother, is not the father.
And the girl.
Against father's signature is fraud.
Father's signature is fraud.
So how will you compare that?
But father filed WS in the suit, it's a partition suit. Father is a party to that.
Then one was alive that time.
Yes.
Okay.
That would be a case matter. During the lifetime, nothing has been occurred.
So is the father. So is the written statement of father.
Exactly.
Oh, still I think that you should settle.
Yes, sir. I'm also interested because it's not my
This
profession.
is not in good to brothers, two brothers and.
Concern with this case is not my professional life actually.
If I believe that this property for which you are fighting is not your property.
It is.
It is not his property. It is not his property. Fighting.
Yes.
I will ask you if you learn something. You are not any sense. Your father learned something. So for that you are blaming.
That's yes.
Manner. Students filed by my husband.
We keep on fighting on technicality. At the end of the day, fact is that this property either belongs to you, not belongs to you. In the father's property. And you people have no right taking fact. In the father's property and you people are fighting on technicality. This happened, that happened. I'm sending to mediation, do it, otherwise I'll take the call. And you will keep on fighting. The children will keep on fighting and everybody will keep.
Yeah, ପାଞ୍ଚଟା ଏଠି କେସ୍ କଲେନି ସେ କଣ ହବ କମ୍ପ୍ଲେନ୍ ମତେ କାହିଁ ଲାଗିନି ହଅନ୍ତା ମେଡିଏସନ ହେଲେ ତ ଭଲ ହଅନ୍ତା
You insist then.
Three of the matters where this honorable court has felt this fraudulent document, therefore it is allowed The team was allowed an amendment was allowed. Regarding your lordship is asked whether the declaration was there or not. That has been allowed. Looking to the, on the face of it, it is a fraud. So therefore, the
do it. I'm sending it mediation here.
no,
Try and do it.
I am also interested.
So that at least you can settle it.
Yes, that is the report. Fingerprint and both and false.
A report from where?
It was sent
by the police.
Same from our instance, and now it is sent to the.
You obtained from private handwriting experts.
It's very Bombay Forensic Laboratory authorized.
You have to get some
Now it is a state forensic laboratory.
every instance of police has it been obtained.
Yes,
It is in force.
on 13/7/24. I am telling
Let the police take it.
yes.
My lord, my point is that let it go to medicine center. Rejection. Because this is the family matter. Shoot. See, five brothers and sisters, my lord.
Petition number.
हमारे इंडियन अपन जो
Brother-in-law of the dispute is arising out of arising of a property dispute. The dispute is arising out of dispute is primarily regarding the ancestral property. The opposite party one is alleging that the petitioner has fraudulently made a will of his father and trying to reserve the property, reserve the property. Therefore, the FIR, therefore, the petition is seeking
Submission memo. Item 46 to 51. Yesterday matter was mediation पे जीवा का था. Without recording my learned opposite party friends name, your lordship may send it to mediation.
I'll pass it at 2 o'clock. I'll pass that.
Leaving your lordship.
That was the understanding.
He says that I can't expressly give consent, so Mr. Mishra's name, that consent document may not appear. Your lordship feels it that
Yes, yes. It should be settled. Why are you not giving consent? This is a difference issue. This is not a family dispute.
No.
Person is different.
Family, it is a family dispute. He says that he is my wife. There is no, not he is his client.
Whatever. You try and find out something.
Without recording my submission. That I have.
A small prayer, my lord. Make a small prayer. Very sorry to record those.
56, 46,
46 all the name. 46 to
51.
51.
For appearance there.
Yes, I have passed that order. Matter awaiting the mediation report. Very sorry to counter. I filed a counter. Very sorry to make a prayer. Come at 2 o'clock. Very sorry to make a prayer.
In the record make out.
My lord, since 159 is there in the entry list, 911 senior is also there. It can be finished within 5 minutes only. After supplementary list of person can. I will come and just see.
Last occasion, my friend was requested me and I examined the matters. There is a ray of hope is there, but it will take some time for disposal.
Because the principal accused is dead. I am not, there is no only the principal is dead.
No, the property is completely responsible. I played it for lordship. There is a ray of hope still I said lords. But the lord.
Only it will be for him or for you, for me, my lord. For him. My lord, the principal accused is dead against him, entire allegation is there against him, and my whole is alive. After the exhaustion.
Let me suggest one. Can dispose of the lordship may proceed on 5 minutes.
ଆଜି ହେଇଯିବ ଆଜ୍ଞା ଆଜି 5 ମିନିଟ ଲାଗିବ ଛୁଟି ପରେ ମୁଁ then you can go to 8, 9 then 9 ରେ ଆସ କରିବନି ନା last morning day ଆଜ୍ଞା
I should not dispose of 5-10 minutes.
item 159 8 ରଖିବେ ସେଇଦିନ ଆଜ୍ଞା 2 ମିନିଟ ସରିଯିବ 5 ମିନିଟ ଲାଗିବ because the entire my lord called for the report. My learned senior has got the report. Entire allegation is doesn't have defined that color. Entire allegation against Raskishwar Punda video who is there. Any mentioning come at 2 o'clock. Right. The interim order my lord may continue. It is madam लिख दे interim order 159.
In fact, he has supplied the copy of the report.
PW8 and PW8 and 13.
PW1 is the informant, who is the brother mother.
One is the informant.
Yes, sir.
2 is the brother. One informant. 2 brother. Brother of informant.
Yes, sir.
And who is
No, brother of the informant, son of the informant.
Son of the informant.
son of him?
Three another son, my lord.
And none of them supported.
None are supported.
And what about 8 and 13 also?
8, 13, my lord. 13, my lord. There are 12 witnesses, my lord, my lord.
No, you have shown me 8 also. Who is 8?
8 also not supported.
No, sir.
All of the material witnesses. You tell.
All of the material witnesses, my lord, they are not they are the family member of the deceased.
Petitioner is accused in so the petitioner is in custody since 8/10/2023. 10/2023. Meanwhile, the evidence of material witnesses have already been recorded in the court below. Out of how many witnesses?
12 witnesses.
12 out of 19 witnesses.
Out of 19 witnesses, 12 witnesses have already been examined. The testimony of all the 12 witnesses have been placed on record.
Yes.
I have perused the evidence brought on record by the prosecution. The vital witnesses, namely PW1, who is the informant, and PW2 and 3, who are the sons of the informant, have not supported the prosecution.
PW8 and also 9. They have not supported.
Apart from that, other material witnesses, namely PW8, 9 and 13.
9, 13 not examined. 9.
9, oh sorry, 8, 9?
8, 9 they have not supported, my lord.
8 and 9.
Also, my lord, also 10 also.
8, 9 and 10.
ସମସ୍ତେ all have been
not supported the prosecution case. Indeed, other formal witnesses, those who have been examined, apart from the material witnesses, have also wriggled out of their earlier version given to the police. In view of the aforementioned, I'm inclined to enlarge the petition on bail, accordingly granted bail. Yes.
18. May I please, Lord?
Since 19
19 to 24 my lord.
19 to
24. Charges submission on 395, 24, 27 of Arms Act my lord.
24.
Not
Okay.
19, 22 my lord.
Not 19.
If they are forwarded on 20.
Huh?
Forwarded on 22.
22,
24.
22 to 24.
My lord.
Yes.
And all were arrested on the same day. All are arrested.
Same
All were arrested on the same.
We have no. Who's disclosure statement?
That is the one PW3 pistol and ammunition were seized from him. Three.
That is Gulav.
My lord.
Gulav.
PW1. Petition number 1. Pistol and magazine. It was seized.
One pistol magazine.
3 pistol ammunition magazine.
Magazine.
2 only mobile number and the vehicle which was used for crime. From petition number 2.
Acha.
And a connected matter, my lord, only mobile phone was seized.
No. And apart from disclosure statement, what you have? Recovery.
Madam, that is the recovery. Pistol ammunition, it was recovered.
And what else? Any circumstance, anything? Any other evidence?
Identified case, madam, only.
No evidence now.
No criminal action. No, that is, there is no also.
No criminal action.
Only that recovery person is there, madam. That without any license, they have kept the pistol and.
So then, first 1 and 3 I am not giving.
First offender,
One and 3 because see, arm check is there. It is recovered from you. So therefore I am not giving.
Maximum punishment.
Two only vehicle is recovered and there is no other evidence.
No.
And for the connected matter also there is nothing. Connected matter in the first matter and number 2 I am allowing. And so far as 1 and 2, 1 and 3 is concerned, I will.
One line. Arms Act with maximum punishment 3 months, 3 years. May let him first offender. One of the
You it is first record. Petitioner.
first and third may permitted to withdraw.
Land counsel for the petitioner seeks to withdraw the present petition insofar as petitioner number 1 and 3 are concerned. And he is pressing this petition qua the petition number 2. The petitioners are the accused in so and so case. Allegation in the petition so and so. The petitioners were arrested on 22/2/2024. Who had given the disclosure statement?
1 and 3 on their disclosure statement. They were
The petitioner number 1 and 3 had given a disclosure statement which led to the recovery of pistol, magazine and ammunition from petitioner number 1 and 2, 1 and 3. On the relying upon the same disclosure statement, recovery was effected from opposite party number 2 as well. Petitioner number 2 as well. From petitioner number 2, a vehicle which is alleged to have been used in the commission of crime has been recovered. Except the disclosure statement, which led to the disclosure statement of the co-accused person, which led to the discovery of the vehicle alleged to have been used in the crime from the custody from the petitioner number 2. No other evidence has come on record. In that view of the matter, I am inclined to enlarge the petitioner number 2 on bail. Regarding it to the period of custody from 22 to 2024 and nature of evidence collected by the police till date, I am inclined to admit the petitioner number 2 on bail. Accordingly, bail is granted. Yes.
connected.
In so far as connected matter is concerned, that is 8714 and before petitioner is accused and so on so forth. So there are 4 accused persons in the present case.
2 cases, 4 accused person.
4 accused person. In the co-accused person, what is his name? Co-accused person. Now, SK
Sanagula and Gulavali were arrested along with the present petitioner. The co-accused persons have given disclosure statement to the police, on the basis of which arm, pistol, magazine and ammunitions were recovered from those co-accused persons. On the strength of the self-disclosure statement, one mobile phone has been recovered from the present petitioner. Except the disclosure statements, we led to the recovery of a mobile phone from the petitioner. No other evidence has come under court as yet. The petitioner is in custody since
Same day, my lord. 22/22.
since 22 to 2024 regarding head to the nature of evidence collected by the police and the period of custody. I am enlarging the petition. Yes.
41. My application discharge having been rejected, I have come up with this. The case was instituted against the petitioner and his wife. They have filed charge sheet. Your lordship may kindly come to
Yes.
page 67.
You are Lakshman Kumar Pradhan
My lord,
and Jyotsna Rani Pradhan.
my lord, husband and wife. Petitioner was
The case registered against Lakshman Pradhan.
both.
Both. Both of them are working.
No. Lakshman Pradhan is a public servant
And
the wife has been added as 109.
Yes.
So now kindly come to page 67. They have calculated the DA amount at rupees 29,91,000.
Yes.
Your lordship got it, my lord?
Yes.
My lord, these properties are involved, the properties are included, the persons who are not accused. That is why the DA has been computed. I will not rely upon any other document other than the charge sheet. I will make my submission on the basis of the charge sheet itself, my lord. Kindly come to page 59.
Yes.
First two assets, my lord. Deposits in the name of Soumya Ranjan Pradhan, 7,674,000.
59.
59.
1,74,130.
132.88.
Yes.
Next is Satyalina Pradhan, 8,31,188.49.
They are son.
Son and daughter. If these two assets are excluded, there is no ODA. And why I should say that it should be excluded, kindly come to page 69. That is the document they have collected during the course of investigation.
69. Yes.
69 is the
Statement of
the accounts officer in the Bulla Medical College. Both son and daughter were reading in the Bulla Medical College. Kindly come to paragraph 4th and 5th from the top.
Yes.
Dr. Satyalina Pradhan then took admission in 3 years PG course, Department of Skin and Valley on 9/8/2012. She had been paid total stipend amount of 12,75,418 during the period from so and so. Likewise, Dr. Soumya Ranjan Pradhan had
a stipend money you got.
Yes.
Okay. Stipend. Those accounts were, those money were accounted for.
Yes. Because they never disburse in cash. It is always payable in the accounts. My account is
Let him come now. Let him come.
Yes, this amount which I have received during my study
and lying in the accounts. These two accounts, 7 lakhs and 8 lakhs, or lying in the account of this daughter and son. This is apparently from this type of amount they receive.
And they are not the accused.
No, they are not even accused. How will you count that? All the item number 4 and 5 deposit that has been made by the wife of the co-accused, wife, the mother and father in the account of the daughter and son.
They have given their statement categorically. And those petitioners have given in writing during course of investigation. This case has been initiated at the instance of the Lokayukta direction. And they have been given sufficient opportunity. After giving the sufficient opportunity, the investigation conducted and charge sheet was filed. No. How these amount will be counted then? This is from 8/9/2012. I'll come to that. Since your lordship knows, since during the complaint was lodged in the Lokayukta, and Lokayukta directed to cause an inquiry given show cause notice to the accused persons, when the raid was conducted, we found nothing, not a single account was found. But during course of an investigation, we found so many accounts. You forget those two accounts disclosed categorically, they have deposited the wife of the from and the statement to fetching the statement. Yes. And they have deposited. They have deposited, that is, the statement of Lakshman Kumar, petition number 1, relevant portion. The petitioner during relevant portion whether you have taken permission from your competent authorities for the business of your wife? No. You don't read those things. I am talking about these two accounts. And those accounts, that is, they have stated whether she had given the daughter, given you any money during the above period to your bank account or the bank accounts of your wife and children. No money has been given by my children to me. So bank account, they are living with their family. I have no need of money. So why they will give me money? My daughter, Dr. Sotalina Pradhan, has not given any money to me or my wife through account transfer, check or any other way. Why could the daughter begin to mean is that on verification of their account, the money transferred for the purpose of that is a stipend money. And the daughter, during the course of the MBBS, he paid. And she is reserving a separate one. That money they are relying now. The PG amount, during the course of PG course, she opened that stipend and she has categorically stated that the stipend money after her marriage and she has resided in a separate mate, we have not taken his income and expenditure, nothing. That's, he should be thankful because we are not added them and accused. Because the money disbursed to their account is stipend money. And they are withdrawn different times from the statement source. Different times they are using their ATM and utilized for their own purpose. They are not given a single pie from that account. Those petitioners are investment for this purpose. Yes. This is part of the doctor. So after the doctor's money, stipend money, that is gone. So it cannot be included. As say that the entire stipend money I have spent. Yes, income tax, the documentary evidence collected from the bank. So that in declaring that, informing that, the document is there. I have given it. That has been given. Where? I have given the counter. I have given everything in counter. So you have to tell me that these two when the stipend money was deposited and when immediate, what was the amount lying there? You will also can see. My reply. Your reply. Page 4 of my reply. Yes. In reply to the plea taken by the petitioner to the effect that the children's income from the stipend has not been taken into consideration, whereas the deposit in Axis Bank account serial number 4 under the heading movable assets have been shown as charge sheet. It is submitted that the documentary evidence by letter number so and so, dated ATG, the Dean of Principal revealed that the daughter of the petitioner, Hon'Ble Sotalina Pradhan, had received net stipend of 1,57,065 during her UG course from the period 27/9/2010 to 2010/2011, out of which 26,555 from 27/10 to 26/1/2011 was considered as she got married on 23/1/2011. After she marries, then the PG type stipend they are saying I am given, which has taken the serial number 27 in the income side of the charge sheet. Stipend received after her marriage was not considered. Similarly, expenditure towards her study amounting 56,520 paid by the petitioner as per the documentary evidence was considered. Therefore, the stipend received to the tune of rupees 12 or 75 during PG course was not taken into consideration as the said amount was meant for meeting her expenditure towards studies, hostel fees, food, cost of living, etc. Her stipend account, SBI account, Bulla, by the account number so that she had spent the said stipend amount for her own purpose as aforesaid by withdrawing in different dates, and there was no evidence of transfer of money to her parents from the petitioners from her account. According the stipend received by her, aforesaid was not considered. Then in respect of son, the son doctor, I didn't follow it. ଯେତିକି ଟଙ୍କା ୟୁଜିଟି ଅର୍ଡର ଯୋଉଟା ପାଇଥିଲେ ସେ ଘରେ ଥିଲେ, ତେଣୁକରି ସେ ପଇସାଟା ଯେତିକି ଷ୍ଟାଇପେଣ୍ଡ ପାଇଛନ୍ତି ତାମାନେ ନେଇଛୁ ବାହାଘର ପର୍ଯ୍ୟନ୍ତ। ବାହାଘର ହେଲା ପରେ she was residing in a separate place with her in-laws and husband. ତାର ହଜବେଣ୍ଡ ବି ଚାକିରି କରିଛନ୍ତି, ତାଙ୍କ ସହିତ ରହିଛନ୍ତି, and it was a love marriage, and ତେଣୁକରି ଯୋଉ ଷ୍ଟାଇପେଣ୍ଡ ମାନେ ପିଜି ପିରିୟଡରେ ପାଇଲେ ସେ ପଇସାଟା ସେ ୱିଡ୍ର କରିକି ନିଜର ଖର୍ଚ୍ଚ କରିଥିଲେ, କାରଣ ହଷ୍ଟେଲରେ ସେ ରହୁଥିଲେ। ସେଇଟା ତ ଦେଖିବାକୁ ପଡିବ ଭାଇଆ, ପୁରା ୱିଡ୍ର କରିଦେଇଥିଲେ, ପୁରା ୱିଡ୍ର କରି ଫର ଏକ୍ସାମ୍ପଲ I'm saying, suppose 12 ଲକ୍ଷ ଟଙ୍କା ଷ୍ଟାଇପେଣ୍ଡ ପାଇଛନ୍ତି, why are you complicating? You simply say that the stipend money which she got, all the money were spent and already exhausted that money matter. Over that the 8 lakh or 7 lakh which is found, this money, where from this money has come? It obviously it has come from them. That is what you want to say. That's showing that part. That I am pressing the statement of a mother. Yes. I'm going to show me the account. Mother, I mean, bank room, जो slip है, जो deposit slip, सही तरह में post कर लो, mother deposit करके show me that. That document that in the statement is there. No, show me that this money was deposited by these two person. No statement also. Their own statement, and they are given in writing statement. I'm a pillar income wrong that. I'm giving it. Well, lots of things. But you have shown me the statement of the accounts officer of the college itself. And he has received the money deposited in their account. I'm placing. Well, lots of things. Why should I doubt unless you show me some other document? statement ପଡୁଛି, ମୁଁ ମୋର ଝିଅ ମାନଙ୍କୁ ମୁଁ ମୋର ଝିଅ ମାନଙ୍କୁ ଓ ପୁଅକୁ ଟଙ୍କା ଦେଇଥାଏ, ସେମାନେ ଆମକୁ କିଛି ଟଙ୍କା ଦେଇନାହାନ୍ତି। ଗତ ଅଗଷ୍ଟ ମାସରୁ ଆଉ ଟେଣ୍ଟ ହାଉସ ରସିଦ ଦିଆଯାଏ ନାହିଁ। ମୋର ପୁଅ ଝିଅ ନାମରେ ମୁଁ ଫିକ୍ସ ଡିପୋଜିଟ SBI ଲିଟିଗେସନ ଶାଖାରେ କରିଥିଲି। ମୋର ପୁଅ ଝିଅ ବ୍ୟାଙ୍କ ଖାତାରେ ମଧ୍ୟ ଡିପୋଜିଟ କରିଥିଲି। ଦିସ୍ ଇଜ ଦ ଷ୍ଟେଟମେଣ୍ଟ। ବ୍ୟାଙ୍କରୁ ଆମେ ସେ ଡକ୍ୟୁମେଣ୍ଟ ପାଇଲୁ, ରିସିପ୍ଟ ସ୍ଲିପ୍ ଗୁଡା। That part of जो दुईटा अकाउंट सन एक्सिस बैंक रे डिपॉजिट କରିଛନ୍ତି, जो 4 नंबर स्लिप्स are there, those slips on the basis of those slips local to examine all those things. After that charge sheet is filed. Local examine that doesn't mean that it is not accepted. কিন্তু এইটা হলো যদি তাদের স্টেটমেন্ট এবং show me the deposit slips. I will bring it to your lordship. আমি যদি ଆଉ ଗୋଟେ statement ପଢୁଛି, ସେମାନେ ନିଜେ କରିଛନ୍ତି ଲେଖିକି, whether Dr. Somaranjan had given you any money during above period to your bank accounts or bank accounts of your wife and children or deposited any amount to the account of Dr. Sutalena Pradhan? No. And whether your son has given any money to you from the stipend amount received by you during the MBBS or PG or MD course? No. So if that is, and whether Dr. Rajani Pradhan has given any money after she got service and earned from her bank account or deposits also, you have stated no. From the children, it comes to the parents. That's not the issue. Whether from parents it has gone to children, that is the issue. The issue is that they have categorically done when the accused person categorically watching you are asking whether you are given it to parents. Parents who involved in the money and deposited in the account of the parents are whether you have deposited money in the parents ନିଜେ କହୁଛନ୍ତି ଆମେ ସେ ଟଙ୍କା ଆମେ deposit କରିଛୁ। Say that children, I don't know, they need to say that children not to have in this case, they categorically stated ଆମ ପିଲାମାନଙ୍କର income asset expenditure ନିଅନ୍ତୁ ନାହିଁ, ସେମାନେ ଆମକୁ ଦେଇନାହାନ୍ତି, rather ଆମେ ତାଙ୍କ ପାଇଁ ଖର୍ଚ୍ଚ କରିଛୁ ଆମେ deposit କରିଛୁ। This is their statement. So what remains to be decided here and put on this 482? No, because see, these two accounts, these two accounts, ସେମାନେ ପଇସା withdraw କରିଛନ୍ତି different time ରେ, କୋଉଠି ଟଙ୍କା ଟିକେ transfer କରିକି ଆଉ ଯୋଉ deposit ହେଇଛି ଯଦି ତାଙ୍କର ଏକାଉଣ୍ଟକୁ ଟ୍ରାନ୍ସଫର ହେଇଥାନ୍ତା ତାଙ୍କ ଏକାଉଣ୍ଟରେ ଏଇ ଯୋଉ ଡିପୋଜିଟ୍ ଆକାଉଣ୍ଟ 4/9/5 ବିଲକୁ ଆସିଥାନ୍ତା ମାତ୍ର ଡିଫରେନ୍ସ ସେମାନଙ୍କ ପଇସା ହବନି କିନ୍ତୁ ଆମେ ରିପୋର୍ଟ ସ୍ଲିପ୍ ପାଇଲୁ ବ୍ୟାଙ୍କରୁ showing that deposit slip. Deposit slip that you ଆଣିନି କିନ୍ତୁ showing that. Then if that is their own statement, if you don't have evidence that these people are deposited in the account of the children, ସେମାନେ ନିଜେ ପରା କହୁଛନ୍ତି କି ଏ ଯୋଉ ବାପା ମା 2 ଜଣ ଯାକ that has to be there should be some evidence because that evidence is doubtful because in the light of the evidence of the statement of the accounts officer 12 ଲକ୍ଷ କେତେ ଜମା ହେଇଛି ତାଙ୍କର ଯୋଉ ଷ୍ଟେଟମେଣ୍ଟ ଦେଇ ଆସିଲେ ଆକାଉଣ୍ଟ ଷ୍ଟେଟମେଣ୍ଟ ତାଙ୍କ ଆକାଉଣ୍ଟ ଯୋଉ ବିଭିନ୍ନ ଟାଇମରେ ଡିପୋଜିଟ୍ ୱିଥଡ୍ର ହେଇଛି ସେମାନେ ଷ୍ଟାଇପେଣ୍ଡ ପାଉଥିଲେ ହଷ୍ଟେଲ ରହୁଥିଲେ ଷ୍ଟାଇପେଣ୍ଡ ଇଜ ମେଡ୍ ଫର ଦେୟାର ଓନ୍ ଏକ୍ସପେଣ୍ଡିଚର ନଟ୍ ଫର ଡିପୋଜିଟ୍ ଆଉ ଯଦି ଡିପୋଜିଟ୍ ସେଥିରେ କରିଥାନ୍ତେ ପ୍ରିଭେଣ୍ଟେଡ୍ ତାଙ୍କ ନିଜ ଆକାଉଣ୍ଟ ସେଇ ଡିପୋଜିଟ୍ ନ କରିକି
month after month. Just my learned friend is perhaps not clear about it. No money has been transferred from the children's account to the parents' accounts. That he is giving emphasis. That is never the case, madam. My case is that whatever money stands in my name, that is from the source which I have already. That's right. That's all. So, there may be. Whether that source is from the college or that source is the parents. So that is the only link. That is our case is from the parents. I'm telling that parents are categorically stopping like that. Let me complete one. Only thing I'm drawing your kind attention to the statement of that accounts officer. He has stated that whatever money, the amount which the children have received during the course of their study. The amount stands in the name of the children are within that limit. That shows that whatever they have received from out of that, some amount was lying in the account.
Now, what is the amount deposited? Have you got the evidence that bank statement? Statement say jama karchunti parents ta account re. Entire money semana just set up that you show.
There may be sporadic incident. The parents might have deposited 1 or 2 deposits, but not the 7 lakhs or 8 lakhs.
That is what I am asking. Let them say the entire amount. ସବୁଠୁ ବଡ଼ କଥା ହେଲା it's a DA case. ସେମାନେ ଦେଖେଇବେ ଯେ ବଡ଼ ଲାଇଜ୍ ଅଫ୍ ସେମାନେ ଦେଖେଇବେ ତାଙ୍କ ଟଙ୍କା ସେମାନେ କୋଉ ବାଟରେ ଟଙ୍କାଟା ତାଙ୍କ ପାଖରେ your document I am saying. See, apparently if two amount, bigger amount, apparently you can't account for, at least he will be free. That is the idea of examining it. Apparently. If it is not apparent case, then he will face. Now, apparently, 8-10,000 ଟଙ୍କା ହଉଛି 29 ଲକ୍ଷ ଦିଏ ଆମେ ଖାଲି ଦିଟା ନେଇଛୁ ଯୋଉଟା ବାପା ମା 8 lakhs and 7 lakhs ଆସ୍ତେ 29 ଲକ୍ଷ
ଭୁଲ କହୁଛନ୍ତି
କହୁଛନ୍ତି ତାଙ୍କ ସ୍ୱାଟ ଆଇ ଅଣ୍ଡରଷ୍ଟୁଡ୍ ଯେ ସେ ଇନକମ୍ ଗୁଡ଼ା ମୋର ନିଅନ୍ତୁ ଯଦି ଆମେ ଇନକମ୍ so for these two accounts I have to explain not scheme only these two accounts other thing
other accounts are there. That is also within the.
I am not conducting trial. If it is apparent case, these two things I will remove. That's all. I'm one. Even then you have a case, then you will face it next week.
I want inquiry. Suppose I am having, I have received 12 lakhs of rupees from my institute. I am having 7.
I'm examining that.
One that kind of purity. I am having 7 lakhs in one account and 50,000 in one account, other account. That means the total amount is 7,50,000. 7,50,000 is well within my legal resources. That is why I am saying.
At the same time, the money you might have shown that this is the amount I have spent for the children's study, that money has to be counted back. He might have said that you got the stipend, the children are independent, they got the stipend, they are taking care of themselves. They are not taking that expenditure. କେବଳ ବାହାଘର କରୁଛନ୍ତି ଝିଅର 2 ଲକ୍ଷ ଟଙ୍କା ସେ କହିଛନ୍ତି ତାଙ୍କ ଷ୍ଟେଟମେଣ୍ଟ ସେ ଫର୍ ଇନଭେଷ୍ଟିଗେସନ ସେ 2 ଲକ୍ଷ ଟଙ୍କା ଜିପେ ପଞ୍ଚାୟତ ଗୋଟେ ଝିଅ ବାହାଘର 2 ଲକ୍ଷ ଟଙ୍କା ଡକ୍ଟର 2 ଲକ୍ଷ ଟଙ୍କାର ଜିପେ ସେ ଜିପେ ଆମେ କେବଳ ଲେଖେଇଛୁ 2 ଲକ୍ଷ ଟଙ୍କା ଏକ୍ସପେଣ୍ଡିଚର ମ୍ୟାରେଜ ଏକ୍ସପେଣ୍ଡିଚର କହିଲେ ରସିଦ ଆମେ ଦେଖେଇଛୁ ବାକି ଖାଇବା ପିଇବା କିଛି ନଥିଲା taken into consideration. My humble what was he was working as range officer, first range officer. And wife was running a tent house business.
My humble
Showing that.
whether my assets
Only say that ତାଙ୍କର ଦିଟା account
ସବୁବେଳେ interrupt କରିବି ନାଇଁ ମୁଁ ଖାଲି ସେ ପଚାରିବି my humble submission that whether the assets stand in my name is well within the legal resources which I have received.
I understand that. That is the yes. After this, yes.
42.
For the opposite party, my lord. Last two order, my lord, kind of glance. The private complaint.
Private?
Last DB proceeding they have challenged. Father-in-law has challenged.
Who is appealing for the opposite party?
Not there. 29/8/2024 order, my lord, kind of glance. 29/8/2024.
Remembering file.
I have filed. I have filed my counter.
You are supposed, you are for petitioner?
No, I am for the
Opposite party.
Your lordship may only clarify one thing. Your lordship in order dated 22/2/2024 granted stay so far in respect of the father-in-law. I kind of glanced to the order dated 22/2/2024. But the trial court is not proceeding with the case. The lordship just clarify that he may proceed so far the other accused person, other my lord, the respondents are concerned.
No, absent.
Your lordship's order is there.
Where?
Order say question. 22/2/2024.
Further proceeding so initiated by the opposite party against the petitioner.
Petitioner.
Pending so state the quad petitioner only. What I will
अपन सब stay करछन्ती सोफा the
quad petitioner again clarification.
Proceed
completely clarified. You want case for the petitioner. In the interest of justice, adjournment. Mr. Diri appearing for the opposite party opposes the adjournment. It is made clear that.
Proceed
but actually perhaps this matter will be withdrawn in future.
Withdraw?
No, may have, because what I have instruction that the present petitioner is the brother of one of the former MLA. So he was perhaps died 2 to 3 days before.
Just reopening
procedure. Yes. Rose Chandra Malik.
Yes.
What do you call reopening date?
Though he is staying at Sambalpur, but his native place in our village. So
then that may be nobody is coming. Yes.
44.
43 Arjun.
43.
Notice serving. Service notice. Opposite party number 2.
Madam, notice it was sought to the son of the informant because he has received the notice. On behalf of my mother, I have received.
On whose day?
On 23/9/24.
Yeah, what?
Man, ଏବେ ଯାଇଛି ଆଉ ଗୋଟେ time.
Because they say that.
And that time reflected only the notice was sought to the OP number 2 on 20.
But I am looking at the proceeding. Now I think I have to look at every line. See the English which they written. It's written, therefore the IIC so and so to serve the notice on the opposite party number 2, indicating that the matter should be taken up. It's very difficult to see every line in the proceedings. These are then everything you look at correct. It is humanly not possible. After doing 100 matters, you can't treat every line. If you see small proceedings, you sign it, then subsequently discover that the entire English is wrong. What to do?
Though it was solved on 23 matter, it another chance maybe we give him that he will appear. Sufficient.
23rd.
23rd.
What are you asking, by the way?
A question.
Question
the entire proceeding. Sir, FIS ନିଜେ କହିଲି ମୁଁ ସମାଧାନ ପାଇଁ ଆଇନର ଆଶ୍ରୟ ନେଲି, wanted to close the suit.
See, since he is not coming despite service, I'll stay the proceeding.
But the only notice served on 23. The 23 I just 2-3 days back before.
Fifth. Consider the state submits that to pursue to the order dated carefully order dated 23/8/2024. The notice on opposite party number 2 has been served to the IHC Manchester police station on 23rd. 23rd, so. Therefore, he submits that in the interest of justice, one more opportunity should be given to opposite party number 2. Accordingly, matter is added to 5th of this month. Okay.
45.
Study matters.
52. Charges. Charges for
That's it.
52.
Technically, charge also proceeding to representation file for adjournment, it's will be adjourned.
Good. Which one?
So, जो possible.
order है सर.
नहीं order. तो आज किसी order हो नहीं.
Simply.
अच्छा.
Wrongly listed करो.
हाँ. ठीक.
52.
I think 52 minute notice has gone to opposite party number 2.
There was service fee. Sufficient. Come to us.
27. More than long. Long than it is
No. May 8 May, the notice was issued. 27 May. One more opportunity. Notice, persons to the order dated 8/5/2024. Notice on opposite party number 2 has been served on 27th of May 2024. However, none appears for the opposite party number 2. In the interest of justice, urgent to so and so. The interim arrangement will on 8/5/2024 shall continue. Yes.
53.
Madam, this is a petition I filed for washing up section 6 of the PID Act along with other offences. Yes. As far as this is concerned, I have already, for the convenience of this honorable court, I have already filed the written note of submission and a small date chart with notes. I would like to draw your kind attention to that. Yes. Yes, sir. As far as this petitioner is concerned, he is the director of Mess of Essence Creation Private Limited. Prior to this case, which is the before this honorable court, prior to this case, the case was registered in the on dated 12/6/2014. On his offences of 420, 467, 468, 471, 406, 120 DIPC, read section 6 of OPID Act. Subsequently, charge sheet was submitted for the offences and we got the bill done. September. Which I will on details. And on 23rd/8/2021, the next page. The petitioner approached this honorable court by CRLNC 1388 of 2021 to file the proceedings arising out of EOW measure PS Kasan that on this one. And on 24/9/2021, this honorable High Court, this court, was section 6 of the OPID Act only. Well, this is a circumstance. This is a first case. Subsequently, in the year 2019, the case where we are concerned with, in 2019, dated 1/2019, another case was registered against same petitioners. Where you went to Supreme Court also. The other side has gone. In the second one, where I have gone to Supreme Court. I have not gone. State has gone. Because that is the interesting part of it. The case was registered by order of this honorable court. Wrongly or rightly, what was registered. Subsequently, we challenged that one. This honorable court said that that is a part of this previous case and it was tagged with that. Once it was tagged with that and 6 OPID Act was passed, automatically that 6 OPID Act was passed from this. Subsequently, the state went to the Supreme Court. However, the state got the SLP was allowed, and Supreme Court observed that this is a separate case. Once it is a separate case, again 6 OPID Act comes to force. Now my you are telling me that exactly my submission is that on the same set of fact the High Court has already crossed section 6. You in the second round you can't have section 6. That's what you want. Yes. And, another one addition here it is that has gone everyone's eye of it is that section 420. Yes, for that just I will take another 1 minute in this FIR. And what stage you have come here? What stage you have come? Preliminary stage. It is preliminary. Nothing has happened. And now investigation is going on. Investigation is still going on. A charge sheet has already been filed. After filing a charge sheet, that was crossed. No, in second case. Second case, after filing a charge sheet, this court directed that charge sheet will be treated as a supplementary charge sheet in the previous case. So and after that, the 6 OPID Act was passed. Now the stage is 6 OPID Act again revived. This is a separate case. This has become a separate case. Though it is same cause of action, whatever it is, against the same accused persons, same thing, everything is right. Very interestingly, and the most interesting part of it is that on the FIR, the allegation is FIR 1425, page 25. Yes. There is it is 21 yes. 21 para 2. The above land measuring 92 acres, 0.92 acres. While Boja Gangapatna, Pata number 474, plot number 842, Panachanka sub-register Khandagiri Bhubaneswar. Yes. What he says, he registered it, he got it converted, he got it ROR, everything else. But his allegation is he didn't get the possession of this. And I'd like to draw your lordship's kind attention to page number 111. 111. Yes. 111. Then for second lesson creation, Khurda, Bhubaneswar, Gangapatna, plot number 474, 842, 0861. This property, the alleged property, of which the informant wants the possession. The petitioner could not get possession. It is because it has been attached by EOW in the year 2014. In the previous case, whatever the title position, it is there with the informant. It is there with the informant. The informant has got it converted to the homestead land. The he has got the ROR. Everything is there. But possession could not be given because it has been attached by EOW. How many statements you have? So one case, previously that one. As is concerned, it is total need for a company. It's a group of cases. Previously, it was a case instituted in 2014. Basing on that, all my properties, entire properties, whether it is human, whether it has been converted or possession has been given or not, equivocally, all the properties of the company were added. Because due to this. And this property is one among them. Okay. For which I couldn't get the possession. In fact, he is telling the truth. He ran after me. He came to me. I suggested him, this is the position, I cannot give you the position. And to get it, he filed a complaint. So that's what EOW should have that one. That is the thing. And I have attached the passing order of this honorable court also. Yes. Basing on which I wanted. So property attached in 2014 and he is asking for that property in 2019. Yes. Yes. Annex 2 ରେ चाहिए ଇଏଟା ଆମ କ୍ୱାସିଂ ଯୋଉଟା ହେଇଛି ଏଗେନ୍ଷ୍ଟ Yes. Yes.
No. No, submission.
Some of the proceeding, how do you give this position?
Like all these submissions are negated by this Hon'Ble Court and upon the 420, section 420, crossing the section 6 of the OPI Act. So now it is not open to decide all these things. But so far as the only ground that section 6 was quashed in the similar case, and in this case also section 6 should be quashed only, that's the ground. Relying upon the Annex 2, judgment of the Hon'Ble, kind of a class to class 26 Annex 2.
26. Yes.
Also got it.
26. No, item
Annex 2.
Annex 2, page 26.
No.
Yes.
So, 1388 of 2000. That's but got the present petition. Council and JP Patri running appeared. Para 3 in the present application, the petitioner seeks to challenge the criminal proceeding by the city case number 14 of 14 and IN number 3 of 15 in relation to AWPS case number 15 of 14. Pending before the Court of Planning PJ officer designated court under the OPD Act, cut up for the offences punishable under section so and so, so and so. Para formula, since the facts of the present case CRLMC are similar to CRLMC number 1296 of 21.
Yes.
And the option knows that that has been held as per inquiry. So it is not.
This is R. Patnaik.
So it has got no binding force.
That order is challenged now.
That order has been challenged in the Supreme Court. Just a order.
What happened?
That has been tagged. I am coming to that. Sasmita Patra order was challenged by the state before the Supreme Court.
Justice Patnaik judgment was not.
Wait, take care of it. That has been challenged before the Supreme Court. That has been challenged in the SLP number 2107 of 2010. And subsequently, the order passed by Honorable Justice R.K. Patnaik also has been challenged. And I will which order High Court. All these both the cases have been tagged in 2107. Something 4 or 5 cases have been tagged, but all those are pending, including this one.
Including this one.
This one is 2107. Notice has been served, and in some cases, in the Justice R.K. the state has not filed counter till date. And
unless those things are decided, how can I take it? Now because R.K. Patnaik, Justice R.K. Patnaik judgment says that it's per incuriam, Rasmita is per incuriam. Which holds the field today?
Because that
one court declares the judgment of the other court judgment per incuriam. Unless the Supreme Court decides which is the judgment holding the field today.
Exactly, that is the thing. That whatever now the ball has been shifted to Supreme Court story. What my submission is, whatever it is, let this matter be disposed of here. And again, the situation and the very honest situation is, if the order comes in favor of the state is going to Supreme Court. If it is go
and get it tagged with that.
Obviously, this is the circumstance. In this way, I want this matter to be disposed of.
Why don't you verify the exact status of these cases?
I can give it right now. It's 2107. I am conducting all those cases there.
I could see. I could see that.
Last Monday, it was listed. Came in this advance list. Then list was landed.
And I don't think, Shubhranshu Body is Shubhranshu Body is the main counsel there. I know. Rashmita Deacon.
So whatever it is, let the matter be disposed of. Yeah, say about.
Another important thing that Supreme as soon as the order of the appeals court passed in this case. Have you got it? That I got it. Yes. Para 9. The Supreme Court clearly directed to proceed in this case.
No, he said that rely upon whatever you dispose it of so that either any of
this order was passed with the Supreme Court, and they are not yes, that section 6 has been quashed in other case. This order was
Supreme Court what is the case?
It is because High Court has taken a view that subsequent FIR lodged by the of the judgment.
Yes.
The High Court has taken a view that the subsequent FIR lodged by the UW PS case number 3 of 19 the present this 3 of 19 to the search and transaction which is the subject matter of UW PS case number 15 of 14. Accordingly, the High Court had held that the UW PS should have dealt with all subsequent FIR under subsection 8 of section 173 CRPC. As such, it has already been filed in UW PS case number 15 of 14. We do not agree with the reasoning applied by the High Court. Thereupon, listen relied upon para 11.
Yes.
Similarly, in the instant case, we find it had to categorize the UWPS case number 15 of 14 and 3 of 19 as part of same transaction, despite the fact that the transaction pertaining to both cases were different, in as much as victims' period of occurrence and place of occurrence altogether different. The first FIR lodged in 2014 related to the commission of offence in the year 2007 and 9, and the subsequent FIR which has been lodged in 2016 related to the commission of an offence in the year of 2012
and 13.
Thus, there is a gap more than 4 years between the commission of the respective offence. The Supreme Court of the place of occurrence and the manner of transactions are different. So, submission that in that case 6 and 6 was requested. This case should be requested. Is no government merit. But then the conclusion para 16. The light of our discussion, the input order of High Court is quashed and the petition filed under section 482 stands dismissed. According to the bail granted to the respondent stand cancelled. It is directed that the respondent shall be required to seek bail and fresh.
You took fresh bail? They took fresh bail? You are not taking fresh bail?
No,
I don't. I am not aware of that.
That's what they say that.
That's a different issue.
No, but I
am yet to know. I am yet to know. That's all.
Real bail you have taken, they say that there are two separate cases. Now you take your bail in this case.
When it's a separate case, every entire process has to be different. I will admit it. That is the only point. What I say is, this is a separate case now. That's for 3 years, since 2019, it was a case tag.
I understand. You say it was a separate case. Earlier in 2013 case. 2014 case, if section 6 is dropped, and if you treat it as a separate case, even then section 6 has to drop in this case. That's what they are holding. Basically, Supreme Court, this High Court says that no, both the cases are similar, so treat it as a 173 and treat it as a supplementary evidence. Supreme Court says no, not supplementary evidence. The incident pertains to 2009 and 7 insofar as the 14 FIR is concerned. And the subsequent FIR pertains to 2012 and 13. So there are two cases. So the bail which has granted in the earlier case is cancelled insofar as the second case is concerned.
Exactly.
And you say, since in the first case 6 was dropped by the court, by the intervention of court, why 6 is involved in second case?
Exactly.
But it can be dismissed that also matter out of this retribution arises as never eight cases are there. And also certificate upon the false
আটটা কেস দেখি বলে বলি
আপন কিছু কিছু
নেই আমরা কিছু করবো আমরা ফেল করবো কিছু মার্কেট দেখানো মধ্যে গোটিয়ে আরে মূল সেজে আজ করছি আজ মতো পাইবে মাত্র সিঙ্গল কেস
eight cases
প্রসন্ন পত্র রশ্মিকা পত্র করছি নট চন্দ্রশেখর ভর্তি নিরঞ্জন পত্র হ্যাঁ এফআইআর করে দিয়ে দেবো कोई भी
one CRLM 43419 was tagged in this case. The record article देखे ना 43419 noting আছে
Tell me, I'll keep it in the pattern. Application, I'll verify myself and you are verified. The Supreme Court position. Well, I am also keeping a tab of that matter. One, not a bill will bar করতে যায় কাই আসুন নেট আসুন হ্যাঁ 07 না কবে any mention is
clear actions so why should I answer?